First sitting with my brother. Yes. Yes, Mr.
Yes, Lordship.
Yes.
On behalf of the bar,
Huh.
with a remorse mind, I would like to inform that one of the founding members of the High Court Bar Association, Mr. Juvenile, he expired last night in Dimapur.
Oh my God.
So in connection with that, some of the members will be visiting in Dimapur, and then the consuls who are in Dimapur, they are also unable to come and attend the court today. Now, my request is, wherever there is difficulties in connection with that, of course, the council members will inform the honorable court that those cases may be accommodated.
Accepted, all accommodated.
Right, Lordship. Secondly, Lordship, another prayer and a request also. This will be from the bar also in the interest of all concern. We have division bench only one day in a week, that is Wednesday, today. And then every week it sits like that, but as and when there are more cases and works, then division bench is constituted even on other days. So my request is, if it is possible, then other than today, tomorrow, day after, or till the next week, division bench may be constituted other than the Wednesday.
I was just going through the list calendar yesterday. I found that 27th is a holiday.
Holiday.
So I was planning that if that be so, I will fix matters on 28th so that we can have a division bench that week. We will miss out. And Mr. Jamir, if I can permit that, if there is a request from the bar through the registry and an urgent matter comes up, take it that it will be allowed. Take it that it will be allowed.
Because when this,
And we would also like to have some work done.
that will be in the interest of our concern.
Yes, sure. That's why we are here.
They pointed out, 27 is a holiday. And thereafter, 3 weeks, Mrs. Justice Longobar will be sitting for 3 weeks. And then many appeals are against her judgments also. So in that case, we will ask the.
You can ask the registry tomorrow. I'll request you not to have it on Friday because my brother will not be here from Friday. So you can have those matters tomorrow. No issue. You can ask the registry to have the matters listed.
Like Justice Krishna Iyer said, miss by a mile, miss by 1,000 miles.
Yes, sure.
So we don't want to miss by a mile.
I'm here. We both are here. You have any matter which one you want it to be heard, get it listed tomorrow. We will come back. And we will have the single benches also. Don't worry about it. And that we will be most loving it.
May I please Lordships, I may be allowed to move the analyst motion. It is trustworthy.
My Lord, I may also be allowed to move on unlisted IA.
For what?
In one criminal appeal. My Lord, in that criminal appeal, the appellant is on bail in the bail. I'm filing for extension of that appeal.
Okay.
Bless my Lord.
जितना जल्दी हो सके लेके आइए. Yes, Mr. 40.
Yes. Lordship, on the request of Advocate General, I request that this matter may be upgraded as first item so that it be taken up before 11:15 or at 2, whichever is convenient to your Lordship.
What is convenient to you?
My Lord, it is on the line.
Sorry, sir. We will have it at the first item itself.
Great.
Next, Lordships. What you said there, we're making 30 months. We think it's today. 0. So we can invest.
Criminal appeal.
Criminal.
It's there from 23. POSCO.
Also.
Okay.
After 2 weeks, my lords.
On the prayer of the learned counsel for the petitioner, comma, not objected to by the learned counsel for learned public prosecutor, registry to list this matter again on 28/5/2026.
Which lot? 2 weeks now.
3/6/2026. Yes,
Lordship, I'd like to mention Act 38. I pray only to honorable court to plan with 2 weeks.
you are for the,
State, Mr. Respondent.
we'll see. Let the matter come up. We'll see. Contractual claim. Yes,
My lord, the Appellate Commission item number 24. I trust. Okay, so this is send for making sure that that matter come up.
you are appearing for,
Respondent number 2 next.
Respondent.
but there is already an advocate affidavit by the government here. You are for the state respondents.
No, my lord, I for your hearing.
Union of India.
Yes.
Okay.
My lord.
But this is a prevention detention matter.
Yes.
So the earlier we get it, it should be heard at the earliest. So, yes, what do you say?
Opportunity has been given.
Yes,
And I don't have any allegations against the
it's all against the state only. If you can file it by next week, we'll allow you.
I'm sorry, but it's
Okay. Don't worry. We give him just 1 week only. Next week we are taking it up.
given opportunity last week also.
Okay, fine. I got it. NDPS matter, we have seen. The affidavit has also come on record from the state government. We have read it. Next week. On the prayer of Mr.
that only.
Z. Engolip, CGC, registry to list this matter again on 25/2026 to facilitate filing of a response by the respondent number 2. Also, no further adjournment shall be granted in the matter to any of the parties to the parties to the proceedings. Also, we'll finish it up on that.
Also.
Yes, madam.
Mr. Lordship, I beg the nation hearing that will be signed. The reading concern has some personal difficulties.
Item 27 is with 28.
No, that's a bail application.
With the bail application, with.
So, when?
First week of June.
It's behind bars. The earlier you get it through, better. He gets a POSCO matter. Paper book ready. You are the public prosecutor. Two. Okay.
I was recently appointed as the declared counsel.
Your name is not shown. I made a note that what happened to the legal aid counsel. Okay.
Reflect my name.
I'm doing that now. I was about to pass an order to appoint a legal aid counsel because it was not being clearly reflected. Fine. A prayer is made on behalf of Mr. Senthianga, learned counsel, for the petition for an adjournment in the matter on account of personal inconvenience. Prayer accepted. A registry to list this matter again on. Can we have it next week? 20th? On 25/2026, reflecting the name of Mr. T. learned counsel appearing, learned legal aid counsel appearing for the respondent number 2.
Lordship, similar to the fight with the
Same. Kali last to not you.
This is where the.
Here.
Oh,
Yes. Done. Yes. 29. We have adjourned it. When do you want it, ma'am? Next week or the week thereafter? 28 Korea. raised 8/28, raised it to list this matter again on 28/5/2026. Done. Mr. You are appearing for the, for the sole respondent is present. Hmm.
She forgot to mention hearing items 31, 32, and 33. Here, my senior Mr. A. Jimmy, he will also be attending the funeral today. So if these matters can come up next week,
A prayer is made on behalf of Mr. Zibumi, counsel appearing for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer accepted. Registry to list those matters again on 28. 28/5/2026.
for here, we're paying for respondent number 2.
You be here. Let us hear the appellant. If I have to allow the appeal, I assure you I will not do it. We will not do it. I just want some clarifications from the appellant. You make your submissions, we'll see what can be done. And give me a copy of that election, that panchayat regulations you have. There is a limitation prescribed in that for filing an election petition. There is a limitation prescribed. Huh? And if there is a limitation prescribed, how can he be permitted to withdraw and refile without accounting for the... Madam, you make your submissions, we'll see. Matter pending for a long time. Yes.
She's not available for appearance today due to some personal difficulties.
Item number
No.
1. Oh, wait. AG is online. Wait. You cannot be waiting like this. You should be active in the morning. Should be rushing down here. Yes.
I'd like to mention item number 35. I believe this matter will be listed next week
Why?
as proceedings out of station.
Who?
Sir City Junior. He will be out of station. He's traveling today.
Mr. Jami was here.
Yes.
Huh?
He'll be traveling in a while.
He's going for the funeral.
Yes.
A prayer is made on behalf of Mr. C.T. Jamil, Senior Counsel, appearing for the petitioner for an adjournment in the matter on account of personal inconvenience. A registry to list this matter again on 25/2026.
There's during this matter.
Interim order passed earlier to continue till the next date of listing.
Your Lordship, same consideration, I put the same consideration was made for item number 34, which was just mentioned earlier. The election matter.
He is appearing for the
He is
appellant.
appearing for the matter.
No,
So
he is
yes.
appearing for the appellant.
Correct.
Tomorrow.
Okay, Your Lordship. That's it.
Tomorrow.
Yes, Your Lordship.
Both these matters we can take up tomorrow. 34, 35. Get it listed tomorrow. Tomorrow.
Yes, Your Lordship.
Yes. Call. Item number 1. No, call item number 1 first.
Item 42.
Item number 40.
40. Okay, 40. Sorry. Treatment goes. Treatment goes.
Orders. Item number 40.
Please.
Yeah.
My lord, in this matter, the appellant has filed an appeal against the order passed by the learned single judge. The order of the single judge is on 9th December 2025. She has a right to file an appeal, nothing is disputed. The state filed a very brief reply, pointing out the consistent various unprovoked allegations made against the learned judge of the High Court, who heard the matter with compassion, day to day gave a lot of leniency to her. Incidentally, once the main orders were being passed, I myself was present in the court. Therefore, her statements were very, very unfortunate. It is true that she's going through a trauma, and it's not that we want to punish her for anything. She may not be in the right frame of mind, I don't know. But before we proceed with the matter, she has an obligation to withdraw all the allegations made against the learned judge in this case, which are completely false, which in effect in law is actually contumacious contempt. Taking into consideration that she is suffering and the child is suffering, it will be may meet the ends of justice, subject to what your lordship feels, that she should give an undertaking she will not indulge in these practices and also withdraw all the allegations. After that, this matter can be heard, my lord. Or if your lordship says I can go ahead, I'm willing to go ahead. On the last occasion, when we filed the reply, she said that she will file a rejoinder to it. She has not filed anything till date.
She has not filed that.
She has not filed. Now, she may explain whatever she wants, but definitely before hearing this matter, she cannot make any allegation. She has been repeatedly making allegations against the lawyers who were appointed. She even made complaints against them to the Bar Council. She has made complaints against the doctors. And she is a lady from Portugal. True, we were once partly a colony of that. Things have changed. They must learn how to behave themselves. Imagine a child
Objection,
from India.
Your Honor.
Don't interrupt
That's
like this.
so
please.
discriminatory.
Don't
Don't bring
interrupt.
all
Madam, you will
me
have
into
your,
your history.
You will have your say.
madam, you will have your
Imagine.
Please have patience.
Imagine what would be the fate of a child from India who is in Portugal. Will they get treatment without insurance? Nothing. And the Christian Medical Center, they've incurred a lot of expenses that they will explain. I'm not coming into that picture at all. But decency requires. You cannot make allegations against these the High Court judges. That is very, very unfortunate. So she has to decide whether she's going to withdraw it or if she's going to insist on it. Then consequences should follow. Now she can submit, madam.
Your Honors, if I may speak.
Madam, you are before a court of law. You have a grievance. Our
Yes, Your Honor.
sympathies are with you. We understand. We are also humans. We understand
Yes, Your Honor.
the need of the child to have a proper treatment. The child is being now kept alive because of the treatment provided by the hospital, who is
Yes, Your Honor.
here. And you as a mother, we can also understand your mental condition. But ma'am, that does not give you a license to go ahead and make allegations in and out against anybody who is appearing in the matter, including the judge who had heard the matter. You can make your submissions on law. We are here to hear it. It's a 2 to 6 power. Our powers are very wide. We can go to the extent to slave a life of a child. We can even become the parent of that child to save her. But ma'am, I want an assurance from you because the reading of the appeal did not give good vibes. I want an assurance from you that you will argue the matter on law. No allegations. On law you argue. We will hear you. We will pass orders as would be required to be passed in the matter.
Yes, Your Honor. Your Honor, I just want to point out that this discriminatory mindset has been the constant throughout these years from the state. This whole matter of they're continuously arguing in the court that my child is not an Indian, my child doesn't have the same rights, deserves the same dignity as an Indian,
Madam,
that I'm a Portuguese national, and bringing up this.
Madam, you have got it in a wrong perspective. That was not the, and I believe from senior counsel like Mr. Balagopal, that was not the intent. What he wanted to project was to show the intensity of the matter. And he was just making a comparison without there being any discrimination meted out to you, or even he may not have even intended that. And we are not going to make any such discrimination. So just leave that.
That is absolutely
You come to the point. You come to the
minority
point. ma'am.
statement.
You come to the point. You come to the matter. The
Yes,
child
Your Honor.
is still being provided the requisite treatment in the hospital.
Yes, Your Honor. The
And
hospital is
that's a
continuing
private hospital,
treatment.
madam. That's a private hospital.
Yes, Your Honor. Your Honor, I will stick to the main points as you've said.
No,
The main point is the child is on my
one thing. You wanted to file a rejoinder. You wanted to
Yes.
file a reply. Have you filed a reply to?
No, Your Honor. Your Honor, I was given these filings just before the hearings, so I preemptively requested time so that I can read what it says and if needs
It's your
be
chance.
file
but
a reply.
we
But
can't give you a very.
after perusing it, after perusing the submission from the state hasn't addressed any of the issues of duty of care. They haven't addressed the issues of the state not providing adequate medical facilities, state-run medical facilities where the child can be transferred. They haven't addressed any of the main issues. They've just gone on different tangents that have nothing to do with the main case and that are just basically allegations without any substance, without any evidence of anything. So in order not to drag the case, I don't see the need to file any response to that. If need be, it can be addressed during the hearing itself.
Okay. Okay.
I have appealed the order mainly because it directly affects Article 21, my child's right to life. Previous orders from this very same court has, sorry, Your Honor, if I could, order dated 15/3/2022 in the original petition in IA 17/2022, the court passed an order stating for the state and the union to pay for the transfer and the foreseeable treatment of the child in Ames, Delhi. The court quoted different Supreme Court orders, and the court came to the opinion that
where is that order?
Yeah, it's order dated 15/3/2022 in the writ petition.
No, we do not have all.
IA.
Where is that order? In the writ petition, not in the writ appeal.
Yes, Your Honor, in the writ petition. There is a slight brief mention of it in the impugned order, but it's not in full. So the full order has.
Can you take us to that?
Yes, in the page. Hold on 1 second.
Ma'am, you are making your submissions from which place?
I'm in Dimapur in Mitsipima Mata. I was trying to come up to Kohima, but since
it's not required. This is fine.
Yes. Okay.
Give me a minute, madam.
Page number 7.
Give me a minute.
Sure.
Mr. Balgopal.
Well,
what's the way out? Not as an age, as a senior counsel.
my lord, actually, the requirement of medical treatment by the child, that definitely is of prime importance. We cannot allow the child to be left in the lurch, whatever she may say or she may not say. That has been our submission from the inception till date. Now, she wanted certain specialists to look into it, and the government of Nagaland provided whatever we have. Our resources are very limited. So in the hospitals where we had 1 or 2 important specialists, their names were given to them. She felt that they were not competent, and some of them are not really pediatric specialists in the field. No problem. After that, when she made this prayer of All India Institute of Medical Sciences, when the petitioner approached the All India Institute, they said, we'll have a Zoom interview on this. They looked into the treatment given by the concerned hospital, and they said, this is the correct treatment. This is another point. So there is nothing about the negligence of the doctors in giving any treatment to her. Unfortunately, the problems which they are facing are definitely very serious, no doubt about it. But whenever such treatments are given, some type of patient should be taken into consideration by not leveling allegations even against the treating authorities. Nobody is her enemy. Therefore, in the present context, what does she want? She has to say. Now, before the Honorable Single Judge, she particularly said that I don't want to go into the negligence of the doctors in this petition and that she will go to the consumer court. That is there. So once that is there, on these particular findings, she says I was pressurized into accepting all these things. Therefore, all these allegations against the learned judge should be expunged.
Exactly. Availability of time. He's like, another state of response at our times will be settling people.
So those observations, my lord, that should be expunged at any cost.
We'll-
Apart from that,
We'll come to that. We'll come to that. Yes.
Yes, I am paying for as a second counsel for the AIMS. The doctors at AIMS and the doctors at
The same thing.
yes, they have made a video conferencing, and the doctors at AIMS, they have said whatever treatment given by the hospital, present hospital, same treatment will be available there because the disease of the child is one of the various of the rare case. So even whatever treatment that is available here will be available in Delhi only. So that is one of the conclusions. And one conclusion was that I have met it personally to see that air transport was given to her. However, air transport was also not authorized because of at that time the disease was because of the disease she is not capable to fly in the flight. We have given her the opportunity of air transport also through the Assam Rifles.
But that was not medical
That was
possible.
not suggested. The doctors of the Air Force.
What is the condition of the girl?
I mean,
Child.
Medically, I don't know, Rashid.
Your Honor, if I may,
Whatever happened.
the AIMS, I would just like to clarify, it's on record. It's the letters from AIMS submitted via the union. AIMS was never ordered to look into the negligence part of the issue. They were only ordered to...
Not concerned. If you have any allegation with regard to negligence, please follow the law. We are now concerned with the treatment of the girl.
No, I'm replying to what the state advocate said. The state advocate said that AIMS looked into the negligence. They did not.
Madam, you just stick to the treatment that is required to be provided to the girl. Child, we want to save her life. You want to save her
But
life.
I also want to make it very clear that AIMS did not opinion anything. They did not investigate or come to any conclusion about whether the treatment was negligence or not. They did not get the medical records. They did not look into that.
Interested in the negligent aspect than the treatment part. Please don't make us have those feelings. We want the treatment to be proper. We are trying to work out a way whereby which the child, it's not only now your child, it's our child also, gets the proper treatment.
Yes, Your Honor.
Only thing odd. We do one thing, Mr. Balgopal. Kindly, because this will not go, this by hearing, it will not neither be able to be concluded, it will never go anywhere. So can I make a request to the state through you?
Please.
That you constitute a committee of your specialist. Have consultation with, if required, with a specialist in AIMS, wherever you feel, work out a treatment regimen that can be provided, because now it is said that the child is not in a position even to be shifted out of the state because of her medical condition. So that if you can give us a thing that which will protect the child, will give her the continued medical attention that she requires. Now we cannot ignore that child. The money will not be a factor here. That child, whatever treatment is to be provided, set up a committee. Let that committee of experts look into it, consult, advise the state government that this is a possibility And because this is a private institute where the treatment, they will have their limitations. They are doing it. We are grateful for that. But this cannot go on. This has to be shifted to a medical facility of the state somewhere. So how you can go about that? If you can give us an idea, if that is permissible or if it's possible, then I think we can take this matter forward. We'll monitor it.
Please, please. In fact, almost the very same words which your lordship is saying was mentioned even by the learned single judge at one stage. So we did bring some specialists, etc., which was not to her liking. But all the same,
We are not concerned with the liking of the state. Balagopal, we are concerned with the liking of the state, not with the liking of the appellant. We are concerned with the child's life now.
Very well. So in that respect, if we can constitute a committee as suggested by your lordships here, and they in turn come up with some advice from a super specialist from a place like AIMS or whichever is a reasonable place they can attend.
Make out a.
Yes. So once that is done, we can report back to this honorable court.
And the treatment in the interregnum should not suffer.
That will not suffer. That they are doing it right now. Christian Medical Center is doing it. But the only thing I wanted to say is, it is a matter of fact that our medical facilities in Nagaland are quite limited, unfortunately.
Because Mr. Balagopal, I would have passed orders that she can be shifted out, but what I'm being told now is that shifting out may be a threat.
Not possible.
We are not going into that. So what best can be done here, under maybe monitoring of doctors of AIMS also, constant monitoring of doctors whenever that is required, that treatment regimen, if it can be worked out and provided here, maybe we can work out something.
So we will constitute a committee of specialists and we will advise them as to what are the details, and partly your lordship can mention in the order also. Thereafter, after the committee is constituted, they can get the views of some specialists. Is there a way out in improving the condition of the child, or whether it's very difficult to come out of?
There'll be two things subject to medical thing. My view is that one is a sustained medical attention that the child will now require and may require for a considerable period of time. Two, whether any better treatment regimen can be brought in so that the child's suffering can be reduced and she maybe can be brought out if possible. Otherwise,
all these details will come in the report.
Yes.
This honorable court about that. Okay. Then as far as All India Institute, where she had mentioned that nothing was mentioned, I got the issue also, where they have clearly said what treatment is going on is the correct treatment.
Let us
in the light of what your lordship has said, without going into any point, let us constitute the committee.
We are not ignoring that. We are just keeping it aside. Right. Let us first ensure the child's life. Thereafter, we proceed with the matter.
That's right. And meanwhile,
yes, sir.
Meanwhile, the allegations which she has very liberally made, they may be expunged. That doesn't show.
That is not coming on record. We are not accepting anything.
Very well.
Madam, we are making out this way out. Let us see how it works. The child's
Your Honor, if I may, please have also opportunity to speak.
Yes, ma'am.
I would just like to say two things. One, it's not allegations. I just stated only the fact of what took place in the court. It's on record.
From raising that issue, I'm stopping you.
Sure.
That issue.
That's fine, Your Honor.
Today, only concerned with the child's life, nothing more, nothing less.
Yes, Your Honor. And second point, Your Honor, State Advocate mentioned Order 19/2025 passed by the single bench, where the single bench requested the same thing that you're requesting today. The single bench requested it of the state. The single bench specifically requested Your Honor, it's right here. The single bench requested what the single bench requested of the state did not do. But now the state is twisting it and saying that I'm the one that didn't like it. No, it's right here in black and white. This is the order. If you read the order, you will know what the single bench requested of them, and they did not fulfill the request of the single bench, which is why the single bench even told them, you can go and get those experts from Gauhati. They are there available in Gauhati, but the state said, no, we don't want to.
Please.
So it's the state that is not doing what the bench is requesting them. It's not me that objected to it.
Complied with. That much you leave it to. We'll ensure that our orders are complied with. Lekha. Heard the appellant number 2 in person. Also heard Mr. K.N. Balagopal, Learned Advocate General, Nagaland. And please, just write it down, please. And also Baki, huh? Upon hearing the Learned Counsel for the parties, at some length, this court is of the considered view that considering the health condition of the girl child, it would be mandated that she is to be provided with a continued medical attention. In order to provide a proper medical attention to the petitioner at a state facility, it would be mandated that the treatment regimen required to be so provided is finalized by a group of specialists. Accordingly, we had proposed to the Learned Advocate General as to whether it would be possible for constituting a committee of specialists to look into the matter and also finalize the treatment regimen required to be provided for the girl child, which may be so required to be provided for a prolonged period of time. Mr. Balagopal, Learned Advocate General, had readily accepted the said suggestion made by us in the matter. First, Mr. Balagopal has submitted that the it will be the Health and Family Welfare Department.
Please.
It will be the Health and Family Welfare Department.
Family Welfare Department.
The Health and Family Welfare Department shall, within 15 days from today, constitute a specialist, a committee of specialists, a committee consisting of specialists, specialist keeping in view the ailments suffered by the girl child, and the said committee shall finalize a treatment regimen for the girl child, as well as identify an institution wherein such treatment can be so provided to the child. The committee, before finalizing its recommendations in the matter, shall carry out a consultation with specialists in a renowned institution like the All India Institute of Medical Science and/or an institution of similar stature, and also incorporate in their recommendations the opinions so driven by the specialist of the institution with which such consultation was made. The recommendations of the committee be placed before the Health and Family Welfare Department. I'll give them a month's time.
That would be required at least.
Within a period of 1 month from the first meeting of the committee after its constitution. The Health and Family Welfare Department shall bring on record in the present proceedings the recommendations of the committee by way of filing an affidavit. Also, Further course of action as would now be required to be taken in the matter shall be so taken after the report of the committee is placed before this court. Full stop. The other objections raised in the matter by the parties to the proceedings would be considered by this court after this court is satisfied that the interest of the girl child is taken care of, and she is being and a system is put in place so as to ensure continued medical attention to her. Full stop. The interim orders passed in the present, there are some interim orders passed. Any interim orders here?
Your Honors, if I may, only the division bench has passed on a previous order for the hospital to continue treatment.
Date.
I'm not sure, Your Honor. So that's the only thing that's been passed.
Orders passed earlier in the present proceedings shall continue till the next date of listing. The registry to list this matter again on
The date of the order, as you mentioned, the order is 21st of January 2026.
said any interim has passed will.
It will continue.
Should we have it, Mr. Balgopal?
Please, any date convenient to the court.
15 days would be 1, 2. So 4 weeks thereafter.
Keep it in July if it's okay, or if any time in January.
We'll have it on 14th of July.
Very well.
Registry to list this matter again on 14/7/2026. It is expected by this court that the report of the committee would be placed before this, will be placed on record before the next date of listing.
Yes, sir.
Madam, in the interregnum, if the child is facing any problem with regard to treatment, feel free to invoke the jurisdiction of this court.
Thank you, Your Honors.
And madam, I don't want you to have those allegations repeated here again.
Just
Yes,
what,
Your Honor.
what my learned friend Jesse is that we have not produced that record. We have already produced that record.
Madam,
Those allegations we have to see, Your Lordship. Because that report was.
we are giving her a long rope. We are giving her a long rope, considering the fact that she is a mother and seeing a child suffering. So we are giving her a long rope. We will try to do that till it is possible. Thereafter, what is to be done, we will do. Thank you.
Thank you.
Very well.
From the supplementary cost list, promotion, item number 39.
May I please, Your Lordship?
Mr. Butcher. Yes.
My lord, it's a preventive detention case, my lord. I was detained under section 3(1) of PIT and DPS Act, my lord. My lord, the very basis of PIT and DPS Act is violated, my lord. The foundational facts of the case is also, my lord, not reliable.
We'll grant an opportunity and then take up the matter. Your name? Name?
My lord, M. Rahman.
Heard Mr. M. Rama, learned counsel for the petitioner. The petitioner in the present proceeding has assailed the detention of, has assailed his detention in connection with.
My lord, page number 22, Annexure 2, my lord, detention order dated 9/4/2026.
White detention order dated 9/4/2026, issued by the Special Secretary (Home) Government of Nagaland. Also, issue notice. Miss so accepts notice on behalf of respondent number 1, 2, 3, 5 also?
Yes, sir.
6, 7. And what about 4?
Lordship, I have served a copy to the union, madam.
On whom have you served? Mr. CGC accepts notice on behalf of respondent number 4. Also, the respondents are to bring on record their response on or before the next date of listing. Full stop. Registered to list this matter again on. We are not giving you a prevention. You just get your. You don't get your affidavit. You get your records at least. We are putting it on 28th. On 28 5 2026.
My lord, may I point out just two things, my lord?
We'll pass an order after we get the records.
Right, my lord.
Even the affidavit is not filed by the concerned authorities. The relevant records be placed on record for perusal by the court.
Service community.
During the course of the day. Let's.
Oblige, Your Lordship.
Oblige, my lord.
For admission, item number 1.
May I please, Your Lordship? Your Lordship, my senior is not available for appearance today due to some medical emergency, so kindly we fix the matter next week.
Lordship, as far as the last order of the court is concerned, it's a query of the court. What further steps have been taken by the state with regard to the setting of blood bank, Lordship? And we have filed an affidavit to that effect, giving the roadmap. Lordship,
Now, after the amendment to the Schedule K,
Lordship.
5B, I suppose.
Yes.
So now FRUs, CRUs, everywhere you can proceed and set up a blood bank.
If
Storage facility.
Storage.
So blood storage facility.
Yes.
And that's the minimum requirement these days.
Yes, Lordship.
You must provide for that.
Yes, and Lordship, as far as the setting up a blood bank is concerned again, because the prayer of the petitioner in the PIL is to set up blood bank in all the district hospitals. Now
That's okay, fine. That would be a wishful thinking, but that is also not something which the state cannot do or need not do.
Because there's a certain criteria we have to fulfill also. Now, as far as
FRUs, CRUs are concerned, you don't require a licensing now.
Lordship.
Only that condition has to be fulfilled.
Yes, Lordship.
See, now with the growing incidence of AIDS,
Lordship.
so if you don't do that, you will be having illegal blood collections.
Lordships.
Right?
Yes, Lordship.
And that would again burden the state because the incidence of AIDS will go up.
Yes.
And that will again burden the state itself.
Lordship.
So a one-time investment in these facilities in the long run will save the state much.
Definitely, Lordship.
Much. Okay, we'll consider.
Lordships.
A prayer is made on behalf of Mr. N. Goza, Learned Counsel for the petitioner for an adjournment in the matter on the ground that he is indisposed. Also, prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registering to list this matter again after. Again on 28/5/2026. 28/5/2026.
Next week, Your Lordship.
Lordship.
We'll have it on 28.
28. Oblige, Lordship.
For admission, item number 2.
Wait, please, my lordship. Lordship, Senior Ken Chaudhary is on his leg at court number 1 in Gauhati to let the matter pass it for some time.
He is for the respondent.
He's for
For the appellate.
Lordship. He'll be appearing through VC, Lordship.
And you are appearing for Mr. Sir, you are appearing for the private response.
Private response.
CDPOs.
Lordship, yes,
CDPOs.
CDPOs.
Supervisor.
CDPOs now, including the appellants, they are all CDPOs.
How did they become CDPO?
During the pendency of the appeal,
They have been promoted.
they have been promoted.
But were they made from CDPO or supervisor directly to CDPO?
Yes,
Senior supervisor to the
So they were made senior supervisor from senior supervisor to CDPO.
CDPO, yes.
But your rules does not contemplate senior supervisor.
No.
How were they
It has
promoted?
not been incorporated in the service rule, but that has been notified by the government.
I see. I see. So it is supervisor,
Senior supervisor
senior supervisor,
and CDPO.
as CDPO.
Yes.
They were recruited to NPSC
Yes.
as supervisor, right?
Yes, right.
Whereas the private respondents had come straight from the road to the office,
Right.
right? And they were accommodated against the direct recruitment quota. That's the only grievance, that's the only projection you have.
Yes.
Subsequently, they were all regularized,
Yes,
right?
yes.
By the cabinet.
Yes.
And they had made this thing because they were under the impression that our promotional avenue is being taken away
Yes.
because of the person. Now you project that they are in the direct recruitment.
Yes, that is that's
Yes, madam.
Yes, Lordship. Pass it over after some time, Lordship.
pleasure.
Abbas.
For admission, item number 3.
They were all there and on the day when they were recorded. These are never gone anywhere in the cadence. That means I board like you should be the
Yes, sir.
department.
That is Lordship. Lordship, Lordship, can you come to order dated 18?
Oh, have you made the verification?
Yes, Lordship. We have prepared a comparative chart, Lordships.
No, do it in this manner. By doing this, what will we understand? You bring it on an affidavit.
Lordship.
So
Because
that-
as per the order, it was to give the instruction, Lordship.
Okay.
So based on the instruction, I have made the chart, Lordship. If Lordship deems it, then I can file a by oath.
Because they have given this list,
Yes, Lordships.
big list.
Yes.
Have you cross-verified?
Yes, that has been cross-verified. Now, this is the chart, Lordship, where it shows how the claim has been made by the respondent number 5. Lordship, for the better understanding of the court, Lordship, if I take the Lordship to the chart. Now, this is for the financial year 24-25. The FGI, the Future General India, was engaged as an insurance company for implementation of the Chief Minister Health Insurance Scheme and the Ayushman Bharat beneficiaries. Now, Lordship, can you come to the claim status in the chart? We have break up into CMHIs, one column, Lordship, then Ayushman Bharat in one column, and the total, Lordship. Now, Lordship, coming to the total claim submitted by the hospitals. Now, we and panel hospitals, where they can provide the treatment to the beneficiaries. Now, Lordship, the total claim submitted by the hospital count, Lordship, can come 21,700 claims were made under CMHIs. The amount was 103 crore, 79 lakhs, 2,345. Under Ayushman Bharat, 77 lakhs, 71,339, 7 crore, 77 lakhs, 39,929. Now the total came to 181 crore, Lordship. Second, the total claim rejected. Now we are concerned with the rejected, Lordship. They have rejected 2,134 claims under the CMHIS. CMHIS is a Chief Minister Health Insurance Scheme, Lordship. And under the Ayushman Bharat, they have rejected 2,844. Now the total amount comes to
8 crores, 17 crores.
yes. Now, this is important, Lordship. The next total claim approved by the FJ. They have approved, but not the payment made, Lordship. Approved, but not made. 19,496 claims under CMHIS and 31,176 under Ayushman Bharat. So the total comes to 145, 96, 44, 740. So this is approved, Lordship. Now coming to the next column. Paid.
So out of the approved amount also, they have not cleared the total amount.
Yes, that is the issue, Lordship.
Mm.
Now, there have been lapses on the part of the hospitals also, Lordship. They have not submitted the claim. Though they have given the treatment, they have not given the claim. So we have segregated that also, Lordship.
So this is prospective. This is
Yes,
once the claim is given.
Yes. Now, the total claim pending payment processing by the FGI, the respondent number 5, Lordship.
This is beyond the other.
Yes, beyond. Now, these are the total. The total of the 4 and 5. Total claim
paid by,
yes, the balance and the claim pending in the hospitals.
Okay, payment and processing.
Yes. So this is in total conflict with the affidavit filed by the FGI.
Just a minute. Total claim by the FG is 19,416. Total claim paid by FG is 17,165. So unpaid PTLR and the unpaid TTLR paid 331. On the school. CMHS to access. Tarupor another 116 pending at the hospital. It we are not concerned because hospital has not met the case. And this cannot be the expenses for everybody else's.
7 4 4 2 4 4 7.
And
it 2447. Mr. Counsel,
something is wrong.
it's come to the third column, third category row.
Yes.
Total claim approved by FGI 1946 for CMHS IHS.
Yes, also.
Right?
Yes.
Total claim paid by FGI is 17,165.
Lordship.
So the difference would be around 2331.
Yes, Lordship.
Now, how do you get this figure 2285? Because if you add 116 to the pending claims also, this will be 2447, not 2285.
Lordship, that will be carried away, carry over of the second column, Lordship. Total claim rejected by FGI. The second.
Okay, fine. That is out of 21,700.
Yes.
2134 was rejected.
Lordship.
19,496 was approved. So 21700. Foolish agreement. Yeah, this sums are not correct.
No, this is information I have received, Lordship. I can get more clarifications.
Get your clarification.
Lordship, I'll do it.
None is missing.
Total claim submitted is.
Yes, the Lordship has already
this
sorted
one.
out.
Total claim rejected is this one.
This cannot be.
This minus this is 18,566.
Because this is the data extract. I've been informed, Lordship. This is a data extract from the portal.
19.
18. Zero. This Lordship.
19,566.
19,496.
Lordship, let it come up with 28. I can clarify. Because these are the information received from the extracted from the data.
You are for the insurance company.
The portal.
You have to do the calculation yourself. Not the figures given by them.
Lordship,
that is not
the calculator.
That is not.
Apparently, Lordship has supplied.
There are some 600 difference in the number of claim submitted, rejected, and approved.
Lordship.
Total doesn't match. Rejected and approved. Sum total should be total claim.
Lordship.
These two must add up to make the total claim.
Yes, total.
So it will have to work out to 21,700.
Yes.
Have the correction made.
The learned, you are appearing for?
Respondent number 4.
The learned counsel for the respondent number 4.
Standing counsel.
Standing counsel, health and.
Nagaland Health Protection Society.
The learned counsel, so and so. Sri so and so learned counsel, learned standing counsel, national.
Nagaland Health Protection Society.
Nagaland Health Protection Society has placed on record the data pertaining to the claims raised by by various hospitals with the respondent number
5
insurance company.
Lord.
On a perusal of the said data, thus we find that the same does not match and there is certain errors in depiction of the total claims
Lordships.
pending as well as the claims paid. Mr. Swanson submits that he be granted time till 28/5/2026 to place on record
Lordships.
updated instructions in the matter. Full stop. Prayer accepted, registry to list this matter again on 28/5/2026, on which date the Learned Standing Council for the respondent number 4 shall place on record the correct data pertaining to the claims raised and paid by the respondent number 5 insurance company.
Lordships. God bless you, Lordships.
For admission, item number 4.
Lights and
These your lordships. I have received an instructions from the state respondents for constitution of state sentence review board. If I may be allowed to place the report before the lordships.
Yes.
My lord, as directed by this honorable board, the state sentence review board have been constituted. However, they are in the process of calling meetings. So
Yes, what do you say?
Lordship.
One of your prayers is now being accepted.
Yes.
So this is an exercise in terms of the Supreme Court order also.
Yes.
The committee has to do first.
Lordship.
already constituted. 30 days time may be traveled by.
Mr. L.T. Santam, learned, you are additional advocate general on instruction submits that the states, the first letters would be big, huh? State Sentence Review Board, bracket SSRB, has already been constituted, and the case of the petitioner for and the case of the petitioner for and the prayer of, and the claim of the petitioner for his premature release would now be considered by the said committee. Mr. Santam submits that he be granted further 4 weeks' time to place on record the conclusions arrived at in the matter by the said board. Prayer is not objected to by the Learned Counsel for the petitioner. Accordingly, a registry to list this matter again on 10/6/2024. 10/6/2026. Mr. Santam shall place on record the conclusions of the board, of the said board, on the before this court on the next date of listing.
May I pray that the same may be listed on 17, my lord. 17, Wednesday.
17th. Okay.
Much.
For admission, item numbers.
It would be there. Education. Take that.
May I please, Your Lordship, I'm appearing on behalf of my senior AC Mumi. As per the last court order, the respondent number 7 and 8, we were supposed to submit the taking report. In last court order.
Okay, we ignored them. You tell us what is the error in the judgment.
Lordship, today we are asked to submit the taking report of respondent number 7.
Get it. We accept that. But what is your take on what is the error in the judgment?
Lordship.
What is the error in the judgment? Item number 5 to 10, along with 17, Albert, 17 is also similar, and uh, 25 and 26. Yes, what is the error in this judgment?
Lordship, the petitioner was serving as a primary teacher, and then he was asked to submit the additional certificate by obtaining a degree of DLA. And then thereafter he obtained
B.Ed also, some cases B.Ed also.
Yes, and then thereafter he submitted the documents. And then we from the department.
Okay, in the first case, the document was submitted from?
The document was submitted from the Elite Institute Coaching Center at Dimapur.
Under?
The center.
Under which university?
Under Janata Rai Nagar, Rajasthan Vidyapat University.
Is it a recognized university?
Yes, Lordship.
No. And how could that University of Rajasthan conduct courses here in Nagaland? It could, even if it is a recognized university, it can only conduct the courses within its territorial jurisdiction, not beyond that. And the persons who had undergone these courses from your Nagaland University, that too through the coaching centers, Nagaland University has come up and said that no, these are not our students. So what is the error here?
Lordship, the petitioner was removed from her service. That the order termination was not the order termination was in violation of all the procedure that was
that the learned single judge has taken care of by referring to Aligarh Muslim University.
Then let the counsel for the respondent be appeared and heard this matter. And leading counsel, let the leading counsel take up this matter, Lordship.
No. Mr. William? You want to say something?
In this office memorandum of 26/6/2016, page 39 of your appeal. Come to page 39. You have referred to the memorandum dated 26/6/2016, is it?
Lordship.
Now this memorandum is at page 60. Yes, page 60, para 3(1). It was required to be done through distance mode of IGNOU or other university recognized by UGC. Yes? Settled position by the Supreme Court that DLED and B.Ed courses cannot be done by any university or any other institution unless a recognition is there from the NCTE. Even a university study center would require the approval of the recognition from the NCTE. If you can show us that Janardhan Rai Nagar Rajasthan Vidyapit under the Rajasthan University had the recognition of the NCTE to allow distance mode of training for any of the DLR or the B.Ed courses. This writ appeal may require a consideration. if that statement does not come from you, there is nothing wrong in the orders passed by the learned single judge.
Lordship, can you pass over for a day? Let my senior take up this matter.
There, what my brother is asking, that query, you have not even gone near that in your writ appeal.
Lordship, I'm not
Forget answering it.
matter of
You have not even gone.
Now, at paragraph 11, we may have it tomorrow. This is subject to what my senior says, but at paragraph 11, page 42, you have said that your entire records in the university has been erased. Is it? Page 42, para 11. Now, in your reply to the show cause, have you taken that stand? It is a page, annexure 9. Where is annexure 9?
Page. So starting about 56. For statutory appeals. Sir. Page 40, 75.
75.
For that, you need to read.
Yes, sir. They can get started.
Come to the hearing. Para 3. Last 3 lines. This enrollment is downloading was in the center. This was in the center. At the key website, definitely is the learned single judge is recorded that finding. Paragraph 18. Does not pertain to the university, and in fact, the said document are not genuine, and these petitioners are neither enrolled nor completed any course in the university. On the prayer of the learned counsel for the petition appellates, registry to list this matter again tomorrow. Albert, tomorrow, along with madam, you can amalgamate along with this item number 17. 17 is also same.
Yes, Your Lordship. 17 also same. Same common and judgment matter, Your Lordship.
Is 17 adjourned? No. 17 is not adjourned. 17 and item number 25 and 26, right?
Correct.
There's an interim, Lordship. There's an interim.
Interim order passed earlier to continue till the next date of listing. Tomorrow, listed tomorrow.
Give your place, my lord.
And give your place.
For admission, item number 11.
May it please, Your Lord.
Yes.
On the last occasion, my lord was pleased to observe that there will be no further adjournments in the matter. Therefore, I'm here for your lordships. And this matter, the limited question raised before your lordship is that the learned single judge proceeded to pass the impugned judgment and order based on an admission by the IOCL that we could perhaps consider the case of the petitioner if he supplied the original lawyer's certificate, which he had purportedly is given a photocopy thereof along with his application. The whole issue arose because he submitted a letter from a different lawyer of 2019, which was the date to the subsequent last date. So therefore, and there, at that time when we rejected his candidature in 22nd February 2019, he had not intimated the IOCL that of his loss of his documents or the reason why he submitted a different lawyer's certificate. So that to that extent, that order was passed validly, but he said that we could consider perhaps. Now, my lord, the appeal herein is based on the apprehension that in view of the judgment of the Honorable Supreme Court in General Manager Business Network BPCL versus P. Saundarya, the admission may have fallen afoul of a certain aspect of the law. Now, I believe that the lordships have the power under Article 226 to distinguish that case from the facts. Given the bona fide grounds, we are not disputing the bona fide nature of this. I may just read a portion of that judgment of the Honorable Supreme Court. I'll be placing it before your lordship after reading this, merely to show what apprehension we have come. I may read just read. Yes.
Sorry, apply for or detail of the Written outlet to the on by the Mati should be notarized to innocent such report below. If photography taken it will help us shortlist going is good one. We will not shortlist creative tasks before it is five. He do the worship of a high he and a vulgar delegate of the same vegetable info provided. Now, Tanta to is a good. There's a fire, there's a chicken land. What from my video person? Same land, second video person. Tante, this is a boy today to stay cancer, and then he is the
If I may read just two paragraphs, in the context of the controversy at hand, reference may be made to the Constitutional Bench decision in natural resources allocation, special reference so and so, wherein the principle that even when the allotment of petrol pumps is made on the basis of a particular criterion, no fault can be found with the decision of the authority as a matter of policy. Even so, a proper method has to be evolved so that the choice can be made out of a pool of eligible candidates without arbitrariness. It is a right principle. Now, the Honorable Supreme Court refers to the Bharat Petroleum Corporation's clause, a particular clause, which is also reproduced in our guidelines, that a detailed advertisement and application has been formulated for such purpose. It has been stated then that the application shall solely be decided on the basis of the information given thereunder. Clause 15, undertaking by the applicant. A, I am aware that eligibility for retail outlet dealership will be decided based on information given in the application above. On verification by the oil company, if it is found that the information given by me is incorrect, stroke, false, stroke, misrepresented, then my candidature will stand cancelled and I will be declared ineligible for the retail outlet dealership. B, I also confirm that I am in possession of the supporting documents in original in respect of the information given by me in this application. And if selected, failure to present these documents in original will result in cancellation of selection due to submission of false, stroke, unsupported information in this application. Since a clear procedure stands laid down by competent authority, there exists no room for any discretion to be exercised in favor of the respondent. The representations made by the respondent terming her application under Group 2 to be an error cannot be considered. Even if she had the requisite land, the rules provided no leeway for a category change to be made. Therefore, my lord, my limited point was that perhaps the leeway. I have only one. I apologize, I have only one copy.
It's okay.
My only apprehension was that even I had made a concession on admission on behalf of the IOCL, perhaps if the law did not allow any leeway or discretion whatsoever, that admission would have fallen.
The facts in this case is that the lady was in Group 2.
She in Group 1. Yes, in Group 2. In Group 2, yes.
She wanted a change to Group 1. So while she had applied projecting as Group 2,
correct,
not as Group 1. So it is in that context that the Supreme Court said it's not permissible because that may not be in terms of your advertisement. But here, the petitioner had, or the respondent here, had applied as a group 1 with documents sustaining that. The only document that was not been able to produce by him subsequently, after his selection, was the originals of the affidavit and the search report, which was given by a learned counsel. So maybe he replicated that same format and got it signed from some other advocate and had given it. Now, the historical facts, documents are not questioned here. The loss is again substantiated by way of filing an affidavit. You have not disputed that. There is no material on record to show that the advocate who had given the initial thing had come up and said, no, I have not done it.
No, per contra, he had submitted, again resubmitted.
That's what I'm coming. This court, basing on your, I'll not say a concession, but your submissions also, the court did not give him a complete relief. They said, if you can produce that documents again from the same very counsel, which will now substantiate retrospectively the documents given, consider. What is there?
My lord, the only problem I found after reading the judgment was the sting in the tail in the last paragraph, where even if the land was there, meaning thereby, in case of a bona fide error, even if later the land was shown to be existent, as on the last application, that error could not have been corrected by any applicant. The last in the paragraph 17, the last line.
Which one?
Paragraph 17, paragraph 17, next page is the last line.
Where
the line ends.
For a category change to be made. Here, there is no category here. Category change is a very serious thing.
Tell me one thing. A person produces the photocopy of an original mark sheet or a admit card with his application form. Luck and chance he loses it. In the meantime, gets a duplicate issued from the same office. Produces it before your ISL authorities for consideration during the final appointment stage. Verification of documents. Now, the photocopy was of the original, and this document that he is now producing contains the sealed duplicate. Just because it is not the original of what was produced to you, would his candidature be rejected? Here is a case where he had an affidavit with him. He had a report with him. Lost. He produces the next affidavit. He produces some document by some advocate who was not the earlier advocate, but it was almost a duplicate of the earlier one. The status of the land did not change. Now, when you raise an objection to it, he gets it from the original person, from the original advocate. Is it not?
Yes.
Then he produces it before you. What is the ground of, on what ground did you reject him?
My lord, stating
what is the ground that someone should not have lost his documents?
My lord, perhaps possibly greater care, more than the greater care aspect, being an administrative authority. The IOCL may not have been a view that it could not come back and review its earlier rejection order.
On what ground was it rejected? I'm asking you, rejected by? Because he had lost the affidavit.
No, my lord, at the time of rejection, that was in 2018. That is the initial order that has not been set aside. The initial rejection order was because at the time of rejection in 2019, he had lost it few days prior, but he had not intimated us, so the authority had no means of knowing why the second lawyer's certificate was produced in original at that point in time.
So you took a decision. So you took a decision against him.
Yes.
He had no notice of why you were taking that decision. Be that as it may, that order should have gone. Now that everything is again fairly before you, when you are not disputing the status of any of the documents.
My lord, I will not argue further, my lord. That is.
Had it been something that land on that particular date had something, or a word is changed, or the status has changed to some extent, even as of today, or someone says, like my senior brother had said, I did not issue that certificate. Even that has not come on record. He says, no, I gave the earlier one. Yes. I'm ready to give a fresh one. Does it need to proceed?
Delay also. Delay the content going. heard Mr. N. Burua, learned counsel for the petitioner, also heard Mr.
N.K.
N.K. Lodha,
Luikam.
learned counsel appearing for the sole respondent. The present interlocutory application has been instituted, praying for condonation of a delay of 294 days in instituting the connected writ appeal, assailing the judgment and order dated 13/6/2024, passed by the learned single judge in WPC number 91/2019. We have perused the grounds assigned in the reasons assigned in the interlocutory application for condonation of the delay in instituting the connected writ appeal. On a perusal of the reasons so assigned, we find that the applicant has brought on record a sufficient cause justifying the delayed filing of the connected appeal. Accordingly, we are of the considered view that the delay of 294 days in filing the connected appeal would mandate to be condoned. Accordingly, the delay of 294 days in filing the connected writ appeal stands condoned, and the writ appeal stands condoned, and the present interlocutory application stands disposed of. As agreed to by the learned counsel for the parties, heard Mr. N. Burua and Mr. Swainsoha, as agreed to by the learned counsel for the parties, the present writ appeal was taken up for consideration at the admission stage itself. Also, the appellate herein had instituted the present appeal, assailing the judgment and order dated 13/6/2024, passed by the learned single judge in WPC number 91/2019. The sole respondent herein had, in pursuance to an advertisement issued by the appellant herein, submitted his candidature for setting up for appointment as a retail outlet dealer. With regard to location on Manja-Dimapur Road on NH29 from Nagaland Gate within 2 kilometers towards St. John's College. First, the respondent herein, in support of his such application, had offered a plot of land at Indecent Village. You will get it in the order para 3. Indecent Village, Dimapur, Nagaland, wide village patta number 429 dated 25/6/2015, bearing registration number 322/15 under Indecent Village Council, situated at Manja-Dimapur Road on NH29. Also, the application submitted by the petitioner being found by this respondent herein being found to conform to the eligibility criteria set out in the advertisement, his case was shortlisted for selection. Accordingly, the respondent was informed via a email dated 19/1/2019 about his qualification for the draw of lots for selection of the retail outlet dealership. The petitioner was required to be present personally for the same, along with a photo identity card. Also, thereafter, on conclusion of the draw of lots, the petitioner being selected, the appellants herein informed him about the same via an email dated 2/2/2019. The respondent was also required to remit an amount of rupees 30,000 online as security deposit and submit a set of documents specified in the email within 10 days with the authorities of the Appellate Corporation for processing of his application for award of the retail outlet dealership at the said location. Subpart. The petitioner, while proceeding to submit the documents as set out, as required by him to be so deposited, found that he had misplaced the affidavit cum declaration executed before the Notary Public, Nagaland on 22/12/2018, as well as the such report issued by the advocate by Sri K. Lotha, advocate, wherein it was certified that the land offered by the petitioner would place him within Group A of the categories set out in the advertisement for consideration for allotment of the dealership in question. The petitioner, on finding the the said documents having been misplaced, the petitioner immediately filed an FIR before the Mokochung Police Station Roman 2, and accordingly a GD entry being GD entry number 2/19 dated 5/2/2019 was made in this connection. Also, as the affidavit cum declaration as well as a such report was a mandated document, the petitioner, on not being able to contact his earlier counsel, Sri K. Lotha, had the said affidavit cum declaration as well as the such report freshly made out through
Sudipta Acharji.
Through Miss Sudipta Acharji, advocate, advocate, full stop. The same, along with thereafter, the respondent furnished the said documents along with the other requisite documents to the corporation in original. Full stop. The respondent corporation, now the appellant corporation, on considering the documents submitted by the petitioner, arrived at a conclusion that the same were not valid for considering the land offered by the petitioner and for placing him in Group 1 category. Accordingly, the petitioner, when I said petitioner, make it respondent, no? The respondent was relegated to Group 3 of the guidelines. First, the respondent approached the authorities for redressal of his grievances in this connection, and the same not having been favorably considered, the petitioner had approached the writ court by way of instituting a writ petition being WPC number 91/2019. The learned single judge, upon hearing the learned counsel, upon hearing the parties to the proceeding and on perusal of the materials brought on record, was pleased by judgment dated 13/6/2024 to allow the petitioner hearing judgment dated so and so, noticing the submissions made by the learned counsel for the appellant hearing, appellant corporation, to direct that in the event the petitioner, that the respondent hearing being given 15 days time for submitting the affidavit from the original advocate, from Mr. K. Lotha, advocate, and in the event such affidavit is so filed within the time frame prescribed, the respondent, the appellant corporation was directed to consider the opinion dated 22/12/2018 as well as the affidavit cum declaration dated 22/12/2018 as if the originals have been submitted. First off, being aggrieved, down below, being next para, being aggrieved, the appellants have instituted the present writ petition. We have heard the learned counsel for the parties and also perused the materials available on record. The learned single judge had noticed the submissions made by the learned counsel for the petitioner, for the appellant before him as follows. Para 12, 13. Para 12 and 13 from here. So, the learned single judge, after noticing the said submissions and also upon hearing the respondent hearing, had proceeded to make the following observations. So, para 17 nobody. 18 nobody. 18, 19, 20, 20 also.
So
we have carefully perused the observations, the conclusions drawn by the learned single judge. First, before proceeding to consider the conclusions so drawn, we would like to highlight that in terms of the stand of the parties to the present proceedings, it is found that from the stand of the learned counsel for the parties in the present proceeding, it is found that the selection of the petitioner of the respondent hearing for allotment of the said retail outlet dealership had already occasioned on 2/2/2019, where 22
selection rejection, madam.
No.
The only selection is
2/2/2019, when an email in this connection was issued to the petitioner. So, accordingly, the rejection of the case of the petitioner being only on the ground that he had not produced the originals of the affidavit dated 22/12/2018, as well as the opinion dated 22/12/2018, and the learned single judge having, on appreciating the issues arising in the matter before him, allowed the respondent to bring on record fresh opinion as well as affidavit cum declaration from the earlier counsel, Mr. K. Lotha, and having further directed that the Xerox copies of the said documents submitted by the petitioner by the respondent be considered as if the originals have been submitted, This court, we are of the considered view that a fresh selection in the matter would not be called for, and it is the selection of the petitioner, of the respondent, as intimated by the email dated 2/2/2019, that would now be required to be taken to its logical conclusion. After. So, having drawn the said conclusion, we have perused the conclusions reached by the learned single judge in the judgment and order dated 13/6/2024, and find that the said conclusions have been so drawn basing on the materials coming on record in the writ proceedings, and no perversity therein is found to have occasioned. The conclusions drawn by the learned single judge is found to be a plausible one, and accordingly, we are of the considered view that the same would not mandate any interference. Are you believing? So, the learned counsel for the appellants have also failed to persuade us to take a different view in the matter. So, in view of the above discussion, the present appeal stands dismissed with, however, it is directed that the appellant shall now proceed with the allotment of the retail outlet dealership by considering the respondent herein to be the selected candidate and thereafter process the matter strictly in accordance with the directions passed by the learned single judge in paragraph 18, paragraph 18 and 19 of the judgment and order dated so and so 13/6/2024.
Orders, item numbers 12 and 13.
Yes, happiness. No problem. I regretfully inform.
Yes, Your Lordship. The leading counsel for the petitioner has some personal difficulties.
Now, is there an amicus curiae, a legal aid counsel appointed for the respondent number 2?
As far as legal is concerned, no, Lordship.
Because we find that the Wisconsin. 376, section 8 post. Session court assembly, respondent number 2. Written service report on still awaited.
What is jail appeal number 2 of 2020? This is jail.
There are two appeals. Two appeals are there. One is a jail appeal, another is an appeal filed by the. What happened to the notices issued to respondent number 2?
No, it was then when it was in the principal seat, if I'm not wrong. What's the section?
22.
তার পিছত আৰু হেৰিলে যোৱাই নাই এডভাৰটাইজমেণ্টলৈ যোৱাই নাই
21 over 4 years.
When did it come back to
22.
Kohima?
22. Okay. Miss, a prayer is made on behalf of Sentianga Learned Counsel for the appellant for an adjournment in the matter on account of personal difficulty. Prayer is not objected to by the learned. Your additional PP, not PP, by the public prosecutor, Nagaland. On a perusal of the records, we find that notices were issued to the respondent number 2. However, there is no representation on behalf of the said respondent. So, considering the nature of the offense involved in the present appeal, registry is directed to appoint a legal aid counsel for the respondent number 2 and reflect the name of the counsel so appointed in the cause list on the next date of listing. So, registry to list this matter again on 28. 28 would be fine. 28/5/2026.
Your Lordship, similar prayer for item 15.
Yes, madam.
Similar prayer for item 14 and 15.
But 14 and 15, you have not even taken steps, ma'am. Why?
Special PP for NIA.
I got it. Special PP, then steps are not to be taken. Same, will you take steps?
Yes.
Same the office note dated 6/5/2026. Also, the said office note reveals that the steps for service of notice upon the respondents have not been taken by the appellant. Although notices in the matter was issued on 18/3/2026. The Learned Counsel representing Mr. Sentienga submits that the steps would be taken within a week from today. Also, registry to on the steps being taken by the appellant, registry to issue notice to the respondents in terms of the order dated 18/3/2026. Registry to list this matter after 4 weeks on a date to be fixed by. Madam, next matter also same.
Item number 16.
Yes.
May I please, my lord?
Yes, Mr. Murek.
My lord, yes, my lord. My lord, the issue has been cropped up, my lord. It's relating to, my lord, custody detention of the accused, my lord, connecting to a criminal case of involving, my lord, NDPS, my lord. Now the issue remains is, my lord, whether that child in conflict with law, whether that he is a juvenile or not. The Learned Court below has, my lord,
Learned Court below had done
the findings and conclusions that
ossification test was done and it was brought to the record that he is more than 18 years. And accordingly, it proceeded with the matter. Right?
yes, Lordship is correct.
No, this today.
It has come up before this court for the first time.
No.
From the Gauhati court.
No. First time.
Oh, no.
I said.
16/9/25. I said. Because of an adjournment. Because adjournment was taken on the last day. Because specific reason.
What is that? Have you filed your objections?
No, we are not. We will not file lordship. We will rely on the records.
On the records. Okay.
Lordship is taken up and make for disposal, my lord.
Okay.
Now, my lord, so far, my lord, textual background, my lord, if I may draw on your attention, my lord. Kindly come, my lord, page, my lord, 71 onwards. Annexure 6 Kuli. I was arrested, my lord.
It's been filed in the
I have not instruction on that.
charge sheet has been filed in the meanwhile.
No, my lord. That part I have no objection, but that will not be the material aspects now, my lord. because I am already, my lord, released, my lord, and that's on bail by inference of this honorable court, my lord, on the first day when motion has been moved, my lord.
Where is the impugned order?
Lordship, there, impugned order, lordship will find the first part, my lord, of certification there was conducted, my lord, page 84, 85, my lord. Annexure 9, order dated 7/3/25. That was the order which was passed by the learned JJB, my lord, conducting ossification tests.
Juvenile justice. But Juvenile Act, Juvenile Justice Protection and Care.
Lordship may refer to section 94, clause 2, 1 and 2, Roman 1 and 2.
What were the documents you had presented before the Juvenile Justice Board?
My lord, there are certain documents like school certificates, birth certificates. Yes, my lord.
Which is the certificate? Where is it?
Lordship may kindly come to annexure, my lord. Annexure, my lord. So equally, my lord. Page 854 onwards.
80?
Page 54 onwards. Lordship may kindly come to page 54 onwards. That is the birth certificate, my lord. Birth certificate, my lord. My date of birth will show, my lord, 22/1/2008, my lord. Page 54.
When was the case registered against you?
At Wokha, my lord. Wokha PS.
When?
It was registered, my lord, on, my lord, 15/12/2024, my lord. I will be, my lord, 16 years, 11 months, 16 days at the time when offense is alleged to have been committed.
Maria Manding Madrasa. এখন Paka High School. He was reading in class 9. It's 2021 of 21 left Paka High Secondary School on 21/12. 31/12/2021. Correct? Aru Mariam in Madrasa Kuse
22/1.
He has left the school of same day. Same year. 31
Class 9 by
21. এইখন স্কুলত 8 বছৰ কাৰণে পঢ়িছে নেকি? 8 মাহৰ কাৰণে পঢ়িছে।
Maria Manding Madrasa class 8 only পঢ়িছে।
On 31/3/2021 he school এৰিলে।
Here.
3112.
He, is it man? 31-3.
Age determination 90, 50 in the Act.
Section 94(2).
94.
Clause 2, Roman 1 and 2, my lord. That will be there, my lord.
94
In my
Roman.
humble submission, my lord. 94 clause 2, Roman 1 and 2.
Yeah. Here.
This records, other than this, no idea, Lordship.
Are there any records on record? Juvenile Justice Board?
No.
The application of the petitioner is on record for determination of his age. Any application was given?
Lordship may see page 84, my lord. That reflect, my lord, what application, what documents I have submitted, my lord.
You have not submitted anything here.
No, Lordship, page 84 of the impugned order, which reflect the documents which I have submitted before the court below.
Okay, show us. Read that documents where you have submitted.
Yes, my lord. Page 84, my lord.
Third paragraph.
Second paragraph, third paragraph, fourth paragraph, my lord.
No,
Last paragraph, my lord.
No, read the third paragraph.
Third paragraph. It is informed by IO that the above name accused is a school dropout and could not collect any of his schooling certificate, deal that nor could a family of the accused produce any of his school certificate other than the Aadhaar card and PAN card showing his date of birth so and so. That is the dispute which, my lord, arose, my lord, and that he has completed 18 years of age at the time of commission of an offense. That is what projection of the IO, my lord. Now, Lordship may come down. Upon hearing the IO, board members and perusal of the record, it appears that Aadhaar card with date of birth showing 22/1/2008 was submitted by the accused CICL through his learned counsel along with transfer living certificate issued by so and so school with conflicting date of birth.
He was not represented.
Only thing, my lord. Now, next paragraph, my lord, that will also be relevant, my lord. That being the case, and there is no matriculation certificate.
Mr. Murray, just a minute.
Upon hearing the IO, it appears that Amanda Aadhaar card was submitted by so-and-so learned counsel, so-and-so Pakka High School conflicting DOB. This is what the IO is stating. This is not his counsel.
My counsel, my lord, my engaged counsel was not even heard, my lord, from the very inception.
Who was supposed to produce the school certificate?
No, school certificate and produce হয়েছিল
সেইটো আইওহে লৈছে
no তাৰ কিলে produce কৰিছে কিন্তু এইটো ৰিজেক্ট কৰিলে কাৰণ আইও দিয়া ডেট অফ বাৰ্থটো হ'ল 22/1/2018
নহয় ইয়াতে who represented the IO before the JJB মই সেইটো কৈছো someone had to represent him his family's witnesses of members of JJB are present IO along with OC Okha Inspector. They represented him.
Your counsel was there on record before the board, Mr. Murray? Your counsel was there? Your advocate was there?
My lord.
Your advocate?
My lord.
Your advocate was on before the board? On the date when the hearing was held, that is page 84 order was passed, your advocate...
My lord, I'm sorry, my lord, I'm not audible, my lord.
His counsel was not there.
Who represented him before the
JJB?
Who was required to produce school certificates before the JJB? JJB has heard the investigating officer,
board member.
One Anambrand SIT Lotha, and the OC Okha. Who was there for him?
Was submitted by accused through his learned counsel.
Where? Read the whole sentence. Read the whole sentence. Upon hearing the IO, board members and perusal of record, it appears that another Aadhaar card was submitted by accused through his learned counsel along with so-and-so having conflicting DOB. This was upon hearing the IO, the board member, and the perusal of record.
And the IO has already said in the earlier paragraph that he has given us this. We did not have school certificates. This certificate was produced before the magistrate, remand magistrate. Remand magistrate said that no, you go before the JJB. Before the JJB, his parents have to be notified, sir. You have to go and give this school certificate. Is it not? Because JJB says there is no certificate from the school. If there was something from the Paka Higher Secondary School, why was it rejected? Ossification will come if the Aadhaar will not. Aadhaar is nowhere there in the JJB, in this juvenile justice. Is there? No, it has to be the matriculation certificate. It has to be the, in the absence of school certificate, it has to be the municipality. In the absence of the municipality, it has to be the board. Where does Aadhaar come in? And they are admitting that there is a school certificate. Unless you contest that, unless the state contests that.
Come to page 80.
And this is before the special judge.
If you remember it, third paragraph.
Seen the birth certificate.
And the Aadhaar card.
And the Aadhaar card which indicates so and so.
However, it is being brought to the notice of the court that the accused was having another Aadhaar card, which clearly proves that the accused was another. They should have taken into account everything.
There was a birth certificate. In the absence of a school certificate, there is only the birth certificate. Why did you reject that? Just because there is another Aadhaar. Aadhaar is nowhere there in the Juvenile Protection Act.
Yes, what do you say?
Well, two conflicting documents are there. Whether is there in the Juvenile Justice.
That is exactly what is to be seen by the board and then come to a conclusion that documents can be proved. If it is not proved, then only ossification. And the remand magistrate had noted that the birth certificate, Aadhaar, school certificate is not there, so maybe subsequently they had brought it. Everywhere it was 2008. So that vital right of the.
Then which is the other Aadhaar card you are speaking of? Where is the other Aadhaar card?
Where is the second Aadhaar card?
My lord, Lordship may see page, my lord. My lord, see page 57.
Page 57 is giving you date of birth as 22/1/2008.
Correct.
And the order of the learned special judge NDPS. That
22/1/2005.
Oh,
Yes. Where is that?
2005. Where is that?
Where is that Aadhaar card?
No, my Aadhaar card date of birth is, my lord, as Lordship has already indicated, 22/1/2008.
Mr. Murray, that
Yes,
Aadhaar
my lord.
your date of birth is 2005. Is it on record?
That is not my contention, my lord.
Yes, suppressed material facts.
No, your TCR would have it. TCR would have it. Your TCR would have it. The police must have seized it. The TCR would have it.
As we have read together, my lord, page 84. What JJB order also, my lord.
Yeah, Mr. Murray, we have got your point.
Did you seize that? Did you seize that particular Aadhaar card?
The CD, the CD, they say the number.
2005. Any copy of Aadhaar card here?
Otherwise, as it report the by exhibit challenge number 34, 2024.
Just let me have a CD copy of that CD. This is the one which is there at page 57.
Number two, প্রথম জায়গাটা কইলে হয় জুভেনাইল করতে না মাইনর পড়ে গেল কোনখন কপি আছে এটা আসলে exhibit
mentioned that.
Simple connection position of the nomination was exhibited to the honorable work. You say what will ever is.
Murek M.K. Murek.
Heard Mr. N.K. Murek and counsel appearing for the petitioner, also heard the learned APP. Having heard the learned counsel for the petitioner for some time, and on perusing the case diary made available, we are of the opinion that a perusal of the trial court records would be necessary for proper adjudication of the case accordingly.
My lord.
Huh?
My lord, may I just indicate one thing, my lord? Otherwise, my lord, what the provisions of law says, my lord, as your lordship has rightly indicated, my lord.
You have,
except, my lord,
Mr. Murray, if you have conviction with this order, kindly carry it upon AP.
Yes, my lord. Even assuming, my lord, if I have to Aadhaar card, my lord, should not prejudice, my lord.
All for the scan copy of the trial court records of what is that? Trial court records of GR case number 72 of 2024 pending before the court of now pending before the special judge NDPS Woka Nagaland. Scan copy scan copy of the trial court records. List again on
After 4 weeks because it takes time.
from Woka scan copy.
Yes.
To get by email.
By email only, scan copy only.
Why would you have a scan copy? You don't take a scan copies through email here.
It comes through email only, scan copies.
Scan copy will come through email. You can have it. List again on the 3rd of June, 2026. Along with the copy of the scan copy. Along with the scan copy of the trial court record.
Obliged, my lord.
Orders, item number 18.
Special judge special judge application
Your Lordship, notice upon respondent for is still awaited.
They notice respond number 4 is not complete. I don't do service return policy. 27.
23/2026.
Thereafter, there is no update. Yes. What is the error in the order, madam? The impugned order? You had gone as a landowner. You had claimed as a landowner. And the other person was appointed on compassionate grounds. Initially on a temporary basis, subsequently against a post. Now you are aggrieved by that. The learned single judge, on considering the stance taken, had drawn a conclusion that no prejudice was caused to you. Seen the office note dated 23/2026, which reveals that the service of notice upon respondent number 4 is not complete. The notices upon the respondent number 4 were so issued by the registry on 27/2/2026. Was a long time had lapsed since the issuance of notice. Accordingly, the petitioner is directed, the appellant is directed to take fresh steps for issuance of notice upon the respondent number 4 by way of speed post. Steps within 2 working days from today. Registry to list this matter again after 4 weeks on a date to be expired.
Orders, item number 19.
That's one I can do so far.
May it please my lordships. Lordship, service notice was issued on 28/1/2026. Now in the cause list,
all are represented. 5, 6, and 7 are represented.
Represented except one. That is in the next. All are represented.
5, 6, and 7.
Yes,
Rest,
all are represented.
You are appearing for?
7 in respondent 7.
And you? 5 and 6.
5 and 6.
Mr. Your name?
No on behalf of MS Naksantila.
Oh, just kindly write it down for. And Miss learned counsels have entered appearance on behalf of respondent number 5 and 6, 5,6 and 7 respectively. Accordingly, service of notice upon the respondents number 5, 6, and 7 is complete. Registry to list this matter.
Lordship, one aspect, there are a bunch of writ petition. Unfortunately, these two were not listed along with the rest.
Okay.
So the item number 19 and 2020 we will come. However, this also to be on 6/5/2026. Other bunch of writ petition came up before this article, so it can be to be listed after 1 week. On 6/5/2026 to be listed after 1 week. But the bunch of writ petitions have not been
just give me one number. One number you give me.
Oh, writ petitions, Lordship. That is our writ appeal. 45, 51, 52 to
45 of
2025.
Along with registry to list this matter along with list this matter again after 2 weeks along with writ appeal number 45/2025.
51 to 61.
Will do. And other analogous matters. 20 also same, you are appearing? Give me 20.
It is also the same, all the judgments are all the same, Lordship, and here 20, respondent number 5 is not represented. However, we have filed talabana on to the respondents on. You have instruction or something?
Who is appearing for respondent number 5? You will be appearing.
I'll be appearing for. I have instructed to appear for respondent number 5.
So yes, 16.
In 10, 11, 13, 14, 16, 17, I'm appearing.
Okay. So who is appearing for 5? You are appearing.
I'm appearing. My lord,
Six,
allow me to make a small submission. My lord, here for respondent number 5, in the single bench, she has not appeared. And I'm being asked to appear for respondent number 5 now only, that is at this appellate stage only. Here is a peculiar fact where the appointment that the petitioner has challenged in the single bench, that appointment has not continued. In fact, a separate appointment has been given to respondent number 5.
Okay, fine.
So
You file an affidavit.
allow me to file a small affidavit, my lord, my lord.
5 you are appearing. 6, 7. 6, 7, 8, 9, 10.
Your Lordships, I'm for 6, 8, 12, and 15.
6,
8,
8,
12, and 15.
12, 15. Then who is there for 7? 9?
Sorry, I'm appearing for respondent 9.
9.
Yes, I've submitted the list.
Only one.
Yes, here I'm appearing for
7, 7.
7, 10, 11, 13, 14,
7, 10,
16.
11.
They have appeared by filing Wakalatnama.
7, 10, 11, 13. Madam, you are appearing.
Yes, 10, 11, 13, 14, 16, and 17.
Also for 7?
No.
But yes.
Filed a Wakalatnama for 7.
7. Yes, yes. 7, 10, 11, 13, 14, 16, and 17. 9. 15. Okay, only 5 was in. Very good. The
We appear for 5.
yes, please, very good. Very good. It is from the records, it is see that the respondents number 5 to 17 have been duly represented by learned counsels. Accordingly, service of notice upon the said respondents is complete. Registry to list this matter. Again, list this matter along with the earlier case, na? Along with WPC number 54/2025 after 2 weeks. On a date to be fixed. The respondents are at liberty to bring on record further pleading if so advised.
Obliged, madam. Obliged, madam.
Obliged, Lordship.
Orders, item number 21.
Respond number 2 service. You do. Good. Good.
Lordship.
Service is complete. We'll condone it and we'll ask our legal aid counsel to appear for respond number 2.
Seen the service report dated 18/2/2026. That the notice has been served on respondent number 2, however, none appears for the respondent number 2 today. This is an interlocutory application praying for condonation of delay of 991 days in filing the appeal against judgment and order dated 28/7/2023, passed in GR case number 347 of 2021 by the Court of the Learned Special Judge, Fast Track Special Court POCSO Dimapur, Nagaland, sentencing the appeal to undergo rigorous imprisonment for a period of 20 years and a fine of 20,000 only. Stop.
Under section 376(3).
Give it from this paragraph, page to paragraph, top paragraph.
376(3), read with that one.
4 of the He's in jail.
He's in jail, madam.
He's submitted with the petition, the appellant is
applicant.
The applicant is serving his sentence in jail, and therefore there is a delay in putting this connected appeal. The delay of so and so days is
here, but we have considered the reasons of some satisfied sufficient delay from the
We have considered the submissions made, the reasons given by the for the delay and being satisfied. The delay of 994 days is 991 days is condoned. I accordingly disposed of.
Straight to
In the criminal appeal,
your number with it.
the criminal appeal you put off, Mr. Swenson considered for the appellant, also the Leonard EPP, issue notice to the respondent number 2 in accordance with the prevalent notification. List
Call
again
for
on
call 40.
list again on 3rd of June.
No, TCR to available. I use one Juliana. I'll look piece of it. The terror track, no terror
What
track.
are the child court records? List again on the 17th of June, 2026. At the top, you can say admit
Admit the appeal. Issue notice.
For orders, item number 22.
May I please, Lordship?
The affidavit has been filed. Have you received a copy?
Yes, Lordship.
What do you?
Lordship, as per their affidavit, the grounds on which we are challenging that the detaining authority has not complied with the mandatory provisions of the NSA Act. Though in their affidavit they have stated that they have complied, but the affidavit which I have received, I have not received
the record. Yes. Yes, Mr. Counsel, you can.
Lordship, may I come directly to the grounds on which I am challenging my detention order? Your Lordship, basically I am challenging the detention order as the detaining authority has not complied with the mandatory provisions of the National Security Act. So, Your Lordship, my first ground, that is page number 16, Lordship, page number 16, close B, Your Lordship. Your Lordship, here under section 3, subsection 5 of the National Security Act, which says that the detaining authority has to, while passing this approved order by the state government, within 7 days, the same has to be reported to the central government. That is the mandatory provision under the National Security Act, Your Lordship. But in the instant matter, that has not been done by the state government. Though in their affidavit, they have stated they have complied with this provision. But the affidavit which I have received, there is no such document which shows that they have complied with this provision.
We will confirm with the records which will now be made available by the state. That we can ascertain from the records.
Yes, Your Lordship, when this matter came up for motion, this Honorable Court has directed the state authorities to place the record of this case before the Honorable Court.
You have the record? They have the records.
And where is that forwarding to the central government?
Kindly flag mark those. Yes, that is your one ground. What is the other?
Other ground is, Your Lordship, regarding section 10 of the National Security Act. While exercising the power by the detaining authority, the matter has to be referred to the advisory board within a period of 3 weeks. Your Lordship, though they have stated in their affidavit that they have complied with this provision also, but that has not been enclosed along with their affidavit.
The first query, Annexure D.
Section 10.
When is the detention order? Detention order is dated?
Your Lordship, that is
page
27, Your Lordship. Page 28, Your Lordship.
27 to 26.
Yes, Lordship.
তাদের কথা বলে 30 not better. Like mark you. Albert, give it to madam. Ask her to flag mark it.
Please make sure the
Wait.
to be
Your Lordship,
Please tell us.
Your Lordship, the report to the central government is flagged at Annex D.
So that was sent on. That must be sent within a period of how many
10,
days?
10 days, Your Lordship.
Within a
So
period of
the 10 days.
10 days.
Your Lordship, the approval of the detention was done on 17 11 2025, Your Lordship.
Detention is of 22, 27? Detention is of?
No, we have to get the dates correct. When is the date of detention? The detention order is passed on 27 to 2026. Is it?
Yes, Your Lordship. That was passed by the magistrate, Your Lordship. So
Magistrate.
that approval was done on 17th. So
Of
that
17th of?
17th of November 2025.
How can it be before?
How it go when beyond 3 months?
Your Lordship, I'm sorry,
You must have some other file.
Your Lordship, I'm carrying some.
Now, 10th of March
Lordship.
to the, after that, when did you send it to the board?
My apologies, Your Lordship. I was carrying some other records.
Central government. Deputy Secretary in Central Government.
But Your Lordship, even in my affidavit, I've clearly stated. And Your Lordship,
We'll come back at 2.
We'll come back.
Madam, you have your this things sorted out.
Yes, Your Lordship.
Have all the dates as required by the Act.
Yes, Your Lordship.
The date on which the order was passed.
Confirmed.
When it was sent to the central government. When it was confirmed.
Central government.
When it was sent to the advisory board.
Yes, Your
When
Lordship.
did the advisory board, and whether each of them were served upon the petitioner.
Yes.
Thereafter, you have also to show to us that he was given appropriate opportunity of filing appeals against each of them.
Yes, Your Lordship. That
The magistrate's order, thereafter the board's order, thereafter the central government approval, everything you do.
Yes, Your
So
Lordship.
kindly mark out those pages.
Yes, Your Lordship.
Huh?
Yes, Lordship.
We'll come back at 2.
Yes, Your Lordship.
Mr. Roman at 2.
Please get the story.
May it please the lordships.
Yes, Mr. Chaudhary.
My lord, item number 2, I prayed for taking up the matter at 2 o'clock. Today there is a special DB at 3 o'clock. So I have some difficulty, my lord, and we have taken time in this case on quite a few occasions. That also I admit.
No, will it take 1 hour, this matter? I don't think so. I think it'll take a few minutes for you.
No, it will take some time, my lord. Can I pray for some accommodation today, my lord?
Tomorrow?
Tomorrow, my lord, tomorrow also I'm slightly tied up. Can it be next Wednesday, my lord?
Okay. On the prayer of Mr. Chaudhary, learned senior counsel for the appellates, registry to list this matter again on 25/2020.
Lord, I understand DB is only on Wednesday. That's why I've said Wednesday.
We have made a thing that whenever, at least when this bench is here, if you want, there is an urgency, make a mention, we'll come back. We'll hold it.
Okay, in any case, my lord, on Wednesday I'll do it. Deeply obliged, my lord.
Yes, Mr. Roman. Madam, we have serialized those records. Isuri. Yes, Mr. Suri.
Lordship.
The first point.
Yes, Your Lordship. First point regarding this non-compliance of Section 3, Subsection 5 of NSA Act, where the state government has to report within 7 days to the central government.
After the order is confirmed by the state government.
No, Your Lordship, as per first detention order, which was passed by the district magistrate.
On 27/2/2026, the detention order is passed.
Lordship.
Okay. So now he has reported to the state government.
Within 7 days, Your Lordship.
The state government, which clause are you reading?
P4.
P4.
Your page 16, clause B, Your Lordship, of my petition. Page 16, clause B.
Page?
Page 16, Lordship, clause B.
No, he is just referring to the ground. 16 to 16. 16 grounds.
I was looking at that. Central government, to the central government, when was it sent? The report to the central government is sent on
10/3.
10th of March, as per records.
Lordship, as I said, since the state respondent has not enclosed this along with their affidavit, so it is not in my knowledge. If it is so,
What we propose to do is, if you give us the ground, we will look into the record, find out whether the document is available.
Lordship.
So here we have found that it is sent on the 10th of March 2026.
Starting Mazur state government or approval details.
Now,
When did the state government approve?
On 10th, Your Lordship. 10th March.
approval by the state government is also on the 10th March?
Yes.
Okay, then next, sir, 10th of March it was approved, 10th of March it was?
So before that, Your Lordship, if the report was reported by the state government, if the same was reported to the central government, then whether it's done within 7 days or not, Your Lordship. First of all,
It was on the same day.
Same day it was.
on the same day. Okay. Then Your Lordship, clause C, that is section 10 of NSA Act, whereby it says that the matter has to be referred to the advisory board within a period of 3 days.
No, 3 weeks.
It's 3 weeks, Lordship.
Section 10.
The grounds of detention within 3 weeks. Now,
It's 2 weeks with.
it was sent on
the 15th day.
16th of March.
Yes, 16th of March.
On the 16th of March, it was sent to the advisory board. You may keep a note of it, Mr. Counsel.
Okay, 16 months. 16 months. Then Your Lordship, third ground, that is page number 17, Your Lordship. So pleaded that in my detention order, it was not that I was already under judicial custody. And for that, Your Lordship, I am relying on my petition, that is at page number 12, Your Lordship. Here in this judgment was passed by this honorable court itself. Page number 12, Your Lordship. That is page number 16, Your Lordship. 12 of my petition. Your Lordship, I may be allowed to read this relevant portion of this particular judgment.
We'll just go through it. You just hold on.
Years ago. Where are the grounds which were furnished to you?
Page 28 also. Was arrested in connection.
It would have asked for it because there is a probability of him getting bail in the near future and his further detention is because
That aspect is not. Was arrested in connection with They would be the man.
Should be in the infection, but if he is released on bail, then he will be taken. If he has not said that he knows that he is injured, then grounds to someone.
Grounds to the
Were the grounds supplied to you along with the detention or they were supplied to you?
Lordship, here my question, as per this judgment, which this judgment was passed this by honorable court itself. Here your this paragraph 6. I may be allowed to read, Your Lordship.
We have read it, Mr. Suryan. Was there grounds of detention communicated to you?
Lordship, that grounds of detention was not stated in my detention order. And this order is clear that in my detention order itself, it has to be reflected. As per the affidavit which was filed by the state, they are saying that it was enclosed as annexer, not in my detention order itself, Your Lordship. This order clearly says that in such cases, the settled principle of law is that the district magistrate must record in his order, not as annexer, Your Lordship. In the detention order itself, it has to be reflected.
But it's not, I don't know. That he's in presently under judicial custody and has been for, this is enough.
Submit your representation, Mr. Counsel.
Yes, Your Lordship. I have submitted my representation on 6/3/2026. That is annexer 6, page number 29 to 39, Your Lordship.
This is
Okay.
Then Your Lordship may kindly come to page number 13. Again, I am relying on of the Apex Code. In this judgment also, it clearly says that in the detention order itself, it has to be reflected that the detaining authority is aware of the fact that I am already under judicial custody. But in my detention order, that is page 28, there is nothing.
Then we'll write this down to my. We should come as a
Acha, where is your detention order?
That is page 23, Your Lordship.
Page?
Page 28. Annexer 5, page 28.
Then you filed your representation, that representation was disposed of.
Yes, Your Lordship. It was rejected by simply saying that there is no sufficient ground without giving any reason.
Where is that?
That is page 41, Your Lordship.
Page?
Page 41, Your Lordship.
What is
Annexer 8,
what
page
is
41.
it is page 40?
Lordship.
confirmation. Page 41 on rejected.
Yes, madam.
Lordship, as far as the timelines are concerned, we've strictly adhered to the timeline as prescribed by the Act. And with regard to the second ground, Your Lordship, that in the grounds of detention, the likelihood of the, I'm sorry, the fact that the petitioner was under custody was not mentioned is misleading, Your Lordship. In the grounds of detention, Your Lordship, I may show you through records, Your Lordship.
Madam, let us go by another.
Yes, Your Lordship.
One where you arrest a person and you give him arrest memo. Is it? And then you give him another 47 notice saying that these are the grounds of arrest. In a normal arrest, is it not? So the arrest memo and the grounds of arrest are two very separate things. Similarly, here there is an order and there is a supplementary to that order, an annexure to that order saying that these are the grounds. Is it? Now, when the order does not reflect, which is passed on 20th of February 2026, that does not reflect that the detaining authority knew that the person was under arrest and that he has moved a bail petition where he is likely to get a bail and therefore we want to continue with the detention. The grounds of detention are signed on 28th of February.
No, Your Lordship, it was on the same day, Your Lordship. Your Lordship, as per the records, Your Lordship. It's there. The petitioner is also conveniently not annexed in the writ petition, but it's in order, Your Lordship.
It's not 28th.
It's on 27, Your Lordship. It was issued on the same day itself. And even the representation, Your Lordship, the petitioner has replied to this grounds of 6. Your Lordship, if I may flag it.
Grounds are just going through the grounds that was given.
Lordship,
Would so it was signed on
28.
28th.
27 of
Your Lordship, the grounds I have not flagged it. I may be allowed to flag it. I have a photocopy with me.
And what about this 2017 judgment? But Mr. Counsel, for the petitioner, you already knew the grounds which were supplied to you that had that recording saying that yes, you were under detention and you are likely to get bail.
No, Your Lordship, as I submitted.
And you have replied to it also. You had the opportunity to reply to that ground.
Lordship, definitely I have made my representation, but that was rejected. But here, I'm relying.
In that representation, now whether the rejection of the representation is correct or not, that is another part. That we will go to later on. Your ground that the detaining authority did not know about your arrest or you are likely to get bail. That part is not reflected in the order. But it was supplied to you along with it was reflected in the grounds of detention.
Everything is the reason. Detention only. Central government already department and these are the grounds. Two grounds and these are the enclosures. This is the Taking dehydration. When it comes.
So why have you not annexed the grounds of detention that was supplied to you with your petition?
Lordship, I have only enclosed that my first detention order, whatever documents I have got, that only I have enclosed, your Lordship.
Then how come at page 20 you say that I have gone
30,
to the grounds of
30,
detention,
30.
page 30?
Come to page 30.
Page 30.
Read the first paragraph.
May I read, your Lordship?
Please.
That I was served with the detention order number so and so, dated so and so, on 28/2/2026, along with the grounds of detention.
Just wait for a minute, you are saying you did not get it?
Yes, your Lordship, since whatever documents I have got, that is what I have enclosed along with my petition.
With which petition? With the writ petition?
Yes, along this instant writ petition, your Lordship.
Before we take exception to your statements, we will give you one more opportunity. Is it your stand that the petitioner did not receive the grounds of detention along with the order of detention?
In that case, your Lordship, I will give my submission in the that though I have received this, but since the rulings on which I am relying, this has to be reflected in the detention order itself. That is my ground, your Lordship.
Sir, trying to skid out of the question of a direct question is not helping you. You had made a statement that you did not receive the grounds of detention. We are trying to understand whether you received the ground of detention along with your detention order or not. Just answer one simple question. Go to every aspect of the matter.
Yes, your Lordship, in that matter, since I have also in my representation, if I made these averments, then definitely I have received it, your Lordship.
Now, in that representation itself, you have also stated when you have got all the grounds of detention, why were the grounds of detention not annexed with the petition?
Maybe, your Lordship, I have not received from the detainee. The detainee, whichever documents I received from the detainee from the jail, that I have enclosed, your Lordship.
So now your contention is that the order has to reflect, and it is not enough if it is reflected in the
detention, Lordship.
Grounds of detention. It has to be reflected in the order also.
Yes, Lordship. As per the rulings which I am relying, your Lordship.
What is the purpose of giving this grounds of arrest? Grounds of detention, what is the purpose?
Lordship, that's basically as per Article 22, I have that fundamental right to receive all those things so that I can take steps in order to rescue me from such situation. So that is the purpose of, yes. Lordship.
In your representation, have you raised this question that these grounds not being supplied to me, I am handicapped from effectively submitting a representation in the matter?
Lordship, I have already stated that I had already made my representation. Whatever I have stated, I have.
Representation, have you made this statement that the grounds of arrest not being communicated to me?
No, no, your.
There's been this. 2017 to GMP 506. Can you have it visible?
It is a. To one, lecture T. One of the schedule annexed as annexure D to the grounds of detention. So paragraph 1 of the schedule. Schedule to by schedule. If the dunia continue to say to no puri lagi. Schedule D, schedule to as annexure D. Paragraph 1 of the schedule annexed as annexure D to the grounds of detention. So there, annexure D. C है, schedule to schedule 1. Paragraph 1. Paragraph 1 to holo pura kahini do. मैंने arrest kahini do. ये arrest kahini do तो नहीं deny do is arrest. Paragraph 2. That subject to the that I am individual operating process. Paragraph 3 and page 33. Page 33, 5, paragraph 4. Paragraph 4 is only for criticizing. Paragraph 5 to Paragraph 5 to Mr. Counsel, if you come to page 31,
Lordship.
From where are you making these submissions? You're making this submission against what?
Yes, your lordship, as I admitted that since.
It's not a question of admission. Now, what is that document you're making that submission?
No, your lordship, my argument is that as I admitted the fact that since in my representation, I have accepted the fact that I am aware of the grounds of detention.
We have ignored that. But what is the material basing on which you have structured your answers in this manner? Just want to know that annexure D, para 1 of the schedule annexed as annexure D. What was that? Because we'll have to compare that with the records.
Yes, your lordship, as I earlier said, since I have made these averments in my representation, so I cannot deny that fact. I'm only saying that the same has to be reflected in my impugned detention order.
Do us one more favor, madam. I'm flagging this with this red flag. You see that page down below, there are some few annexures written, annexure A, B, C. Yes? We have been able to trace out annexure A, B, and C. Now there is another document, annexure D, D1, and E. Which are those?
Yes.
With annexure D, we want to see.
So D is a.
So we need to go into the
Mark it in pencil, D and D1, and circle it with green flags.
But was this said to him?
Yes, Your Lordship, and even Your Lordship, in the list of annexures I've given Your Lordship, all the necessary documents which we had served to him, he had also signed, and we had kept a copy with us, Your Lordship. It's starting from page 676 to 117, Your Lordship.
76 to 117.
Whatever he had received, he has also made, we made, he was made to sign in our office copy, Your Lordship.
76.
So it starts from page 76 to 107.
I needed that from the.
So the annexure would, I have flagged it from annexure G1. It will start from G1. Your Lordship, and also in annexure D1, he had, this is a acknowledgement. He had signed there's a signature. His signature is appended in annexure D1. If I may, annexure D1, which Your Lordship had pointed out, this is a declaration that he had received the grounds of detention and that he had understood, Your Lordship, the annexure D1.
I don't know the question. I don't know the. The advisory board, it was sent to the advisory board on 16/3/2026, huh?
Yes, reference.
And when did the advisory board take the decision?
It was on 13/4/2026. On the 46th day, the statutory period is 49 days.
13/4/2026.
13/4,
13/4.
Yes.
2026, board decides.
Yes, that was on the 46th day. And the statutory period is 49 days. So it is well within the timeline.
And that he has not taken as a ground also. When did you file this? 7th of April, huh?
During the pendency of this.
Okay, after this board. Yes, anything more?
Lordship, besides that, the representation which I had submitted, which was rejected. In that said representation, simply it has said that there is no merit in my representation, and simply my representation was rejected without giving any specific reason why there is no merit in my representation. And then, Your Lordship, no doubt there is this preventive law, but the sections under which I have been booked in the instant case, those cases can be tried under ordinary law. There is no requirement for preventive law, Your Lordship.
Your Lordship, in this case, we had information that he had moved bail. So that was also in the grounds of detention. But we were in the knowledge that he had moved bail. And in the records will also in the records the application for bail as well in the court's order. So the detaining authority were well aware that he was likely to move on bail. The records.
Annexure C last ground. Annexure C last ground, that is.
So as per the records, Your Lordship, the bail application is flagged as Annexure B. And even in the Schedule C and D also, we have made a mention he has moved bail. We were in the knowledge that he had moved bail. Your Lordship, in my affidavit, I have specifically categorically made a statement at paragraph 7, Your Lordship, page 6, regarding this, Your Lordship. Page 6, paragraph 7, Your Lordship.
Okay.
So, Your Lordship, in this view of the matter, Your Lordship, the detention order, there is no infirmity in the detention order, Your Lordship. All the timelines has been strictly, minutely adhered to, Your Lordship.
Received it on 28th or what? 28th.
Next day.
Yes.
Yes, sir. Anything more?
Your Lordship, Your Lordship has asked me the questions regarding whether I am aware of the grounds of my arrest or not. Since I have made those I have admitted that. So in that view of the matter, Your Lordship, I am reiterating that even though I have received or it was within my knowledge, but as I stated at page number 12, the ruling which I am relying. So my only technical issue is that whether that has to be reflected in my detention order or not. And that has not been reflected, Your Lordship.
And madam, when that order was approved,
It was on 10th.
it was
10th of
approved on
March.
the 10th.
Yeah.
Was he told that it was approved?
Yes, Your Lordship. He was.
Now, while giving him that approval, while furnishing him the approval,
Yes.
did you inform him that he has got the right to make an appeal or a representation against him?
Yes, Lordship, Your Lordship. It might be in the reports, Your Lordship. I don't have a copy right now.
The approval is that page, annexure.
Page 40, Your Lordship, Annexure 7 of my petition. Page 40, Annexure 7.
Presentation. You can be rejected.
The judgment which you are referring to,
Lordship.
do not know the facts of that, but then perhaps you would also be required to go through paragraph 7, which you have quoted in the revision petition. Of that very judgment, the Supreme, it has referred to another Supreme Court case which says that if the reasons are there while coming to the conclusion that the detention is necessary, and those are supplied to you or are available on record, that will be enough.
Lordship.
If an order is passed after recording satisfaction in that regard,
Lordship.
so the records show the satisfaction of the detaining authority in that regard. When the grounds were supplied to you, it records all these things, that you were in detention, that you have moved a bail petition, that you are likely to get bail on that. And then the order is passed. A formal order is passed. What do you have to say on that?
Lordship, yes, regarding this approval order, that is Annexure 7 of page 40.
Order itself.
After this approval order, Your Lordship, there is no confirmation order from the government. There has to be confirmation order of my detention, but there is also no confirmation order. And as Your Lordship has noted that this approval order, that is page 40, Annexure 7, has also not been Yes.
Advisory board's opinion here, ma'am.
It's a
If, if,
mixture of.
actually, they don't do the absence, that is not a timeline to do it. Itu kali open.
Anything more?
Lordship, I'm done.
Yes, madam. What do you say about his on the judgment? That the order has to reflect.
Your Lordship, on the, if I may refer to Section 3, subsection 4 of the NSA Act, Your Lordship. Your Lordship, when any order is made under this section by an officer mentioned in subsection 3, he shall forthwith report the fact to the state government to which he is subordinate, together with the grounds on which the order has been made, and such other particulars, in his opinion, have a bearing on the matter, and no such order shall remain. Your Lordship, this particular subsection will show that, like, along with the grounds can be enclosed with it. It's not necessary that the grounds, the order itself, Your Lordship.
No, we are not on that. We are not on that. He has given us a judgment.
Okay.
Have you seen that? Have you seen page? Kindly come to
Your Lordship,
page.
I'm not.
No, you have the petition with you?
Yes, yes.
He has quoted it. No, he has quoted it.
It's page 12, Your Lordship.
He has quoted it. At paragraph 6.
Paragraph 6.
No, page 12. You have page 12?
Yes.
There is in the middle, he has quoted a paragraph 6. In such cases, it is settled principle of law that the district magistrate must record in his order that the detainee is already in jail, but there are cogent and reasonable grounds to apprehend that he is likely to be released on bail. Now, your death sentence is missing in the order of detention.
Your Lordship, but the order of detention has to be read with the grounds of detention, Your Lordship. It had to be read along with the grounds of detention, Your Lordship. And in the grounds of detention, it's clearly mentioned, Your Lordship, that
You are
there's
referring to section 8
yes, Your Lordship.
of the NSA Act.
It was
Thank you. You are Mr.
P. Suren.
Heard Mr. Swenson and a counsel appearing for the petitioner. Also heard, madam.
holding in a hand.
You are appearing as the government
Government.
advocate, appearing for the respondent.
Just put this in one rubber.
The records in file number, file number to Sana,
CON,
which have been produced by the learned government advocate, are retained till delivery of the judgment. Stop. Counsels have been heard, judgment is written.
Lordship.
Put this records in a packet, seal it, and give it to me. Better to let him go.
For orders, number 23.
Item.
May I please lordship, my lord, by order dated 6/5/2026, His Honorable Court has directed the petitioner to file additional affidavit incorporating the additional ground taken by the petitioner. And my lord, I have received that affidavit yesterday, so I may allow 2 weeks time to file affidavit, my lord. In that.
Here the order does not reflect, or does it reflect that he was in custody when he was put under detention. Where is the order of detention?
The order is in page number 33, Your Lordships, Annexure 5. The order does not reflect that particular sentence has not been reflected in the.
But you had not taken this ground in the original petition, right?
Your Lordship, that particular sentence has been mentioned in their schedule. But
did you take this ground in the writ petition?
Your Lordship, similar ground, not exactly that ground, but
that is why this court may have directed you to file a additional affidavit.
Your Lordships,
right?
In the previous occasion, when the petition was filed, the grounds which was not raised in the petition that was laid before this honorable court.
Where is the additional ground that you have taken on that ground?
Your Lordship, that is in my additional affidavit, Your Lordships. It starts from page number 5, paragraph 5.
That specific point that the order does not reflect that it is
specifically in that line. I have not mentioned the Lordship in the grounds, but
in did you receive this grounds of detention along with the order? Did you receive it?
Yes.
Schedule in the schedule.
Annexure.
In the schedule, where is it mentioned?
In schedule.
Page 42.
Yes, 42, Your Lordships. Para 4.
Page 46 or doesn't.
Your Lordship, in that line, I've submitted the ground, which is in page number 6, para 3. That particular grounds may I read for this honorable court, Your Lordship.
Para 3 of the original writ petition?
Additional affidavit, Your Lordships.
Yes, you were saying you have the records?
Yes, my lord.
You want to file, have you filed your?
No, my lord. So I may be allowed 2 weeks time to file everything, my lord.
And you had produced these judgments.
Yes, your lordships.
To what
I'll be
end?
producing your lordships.
To what end? We have the copies. To what end do you, for what did you produce? What was the ground of law?
What is the issue?
Your lordship, the grounds which I'm taking is, I have mentioned in my petition also that a bail has been moved. And in the schedule of, which is a part of the detention order, the detaining order has mentioned that bail has been moved, but that should not be a reason for passing a detention order. And I'm placing my reliance on one judgment which has been passed by this honorable court, which I may be allowed to submit, your lordship. And this ground I've taken in my additional effort in para 3, page number 6. Your lordship, in this case, I'm relying on para 22, your lordships. Page number 14, para 22.
Page number?
Page number 14, para 22 of the judgment, your lordships. May I read, your lordships? Your lordship, as well as para 25 of the same judgment, I'm relying on.
So can you tell from the records whether on the date of passing of that order, there was any bail petition moved?
Has moved bail on 21/20/26. In 21/20/26. When were you detained in the first phase in that criminal case?
Oh, no. This is another person. This is
29 December 2025.
Hmm?
29/12/2025. I've mentioned this in my petition in para 2, your lordships.
29/12/2025.
And bail application was moved on 21/2026, and which was fixed for hearing.
Okay. Off it.
By when can you file your objections? Shortest possible time.
Within 2 weeks, my lord. In the next reasonable date, the matter can be disposed of, my lord.
Now, with or without your objections, you already know what are the grounds taken.
Yes, my lord.
Judgment is going to rely on.
If your lordship insists the record is here, then the matter can be taken up. Then
Your lordship, since
without your objections, without giving you that opportunity, our disposal will only open doors for further.
My lord, in fact, now also he is submitting beyond the pleadings, my lord. In the grounds, he has not taken this ground, my lord.
Okay, fine.
Lordship, that has been taken in the additional.
Additional affidavit. Have you got a copy of it?
Yes, I've got, but
in the additional affidavit also, he has not taken this ground.
No.
You file your objections.
Yes, my lord.
Lordship, in that respect, if opportunity is going to be given to the learned PP, then I have a prayer, your lordships. There is one ground which I would not have taken until this morning. So earlier occasion, the detainee could not ascertain on which date the advisory board had set. As per section 10 of the NSA, the materials should be placed before the advisory board within 3 weeks from the date of detention that is there. So the detention order in respect of the present detainee was passed on 21/1/2026. So the advisory board should have set on 12th. And all the materials of the present detainee should have been placed before the advisory board. But it has come to the knowledge of the detainee, which has been informed to us only this morning, that the advisory board set on 21.
No, that the records will reveal.
Yes, your lordship, but I may be allowed to take that grounds. And if necessary, I may be allowed to amend my additional affidavit.
See, if we allow you to file an additional affidavit now, then again after that we have to give him around 2-3 weeks to file his reply objection.
Yes, your lordship, I can file tomorrow itself, your lordship. And in that respect, he can file a reply in that.
Then, my lord, for the
Come to volition. Give me that NSA. Just possible that. No, it's When was it forwarded to the NSA, but to the advisory board?
Advisory board. I have to check the record, my lord.
Consideration.
We will give you time, we'll give you 2 days time to
Lordships,
file your additional affidavit
Lordships,
as requested by you.
Lordships,
Thereafter, we'll give him 2 weeks time
Lord.
to file the objection. He has to have the time. He has got an affidavit yesterday, he is getting an affidavit day after tomorrow, is it not? The 2 weeks time will grant him and on the next date.
Lordship, if
Because
1 week may be granted.
he has suggested we take it up today itself. He has
Yes, Your
suggested, but the thing will be, if we address grounds which are not there in the petition, it will not be proper. If we don't give him the opportunity to reply to your grounds taken, that will not be. So this 2 weeks has to come. I understand the urgency, yes.
My submission, my lord, for the interest of justice, let him withdraw this additional affidavit and whatever ground he want to take, he can take and file it additional affidavit, my lord.
We are giving him the opportunity to file one more affidavit within the next 2 days because he got some information today.
Yes.
You would have the opportunity to answer all the affidavits
Yes.
that I go within 2 weeks.
Yes, my lord.
Heard Mr. Swinson counsel for the petition and also heard. You are appearing as the GA.
Yes, senior government advocate.
Also heard the senior government advocate, Mr.
E.T. Papa.
What is pending? I don't know. Pending, I think.
The learned counsel for the petitioner has submitted that the additional affidavit in compliance of the additional affidavit as the additional affidavit in accordance with the liberty granted by this court on 6/5/2026 has been filed on 12/5/2026 and the learned senior government advocate has acknowledged receipt of the same. The learned counsel for the petitioner has submitted that today morning he has been furnished with some further instructions which may allow the petitioner to take an additional ground in the petition, full stop. Accordingly, he prays for the liberty to file another additional affidavit to bring on record the further grounds proposed, full stop. Giving liberty to the petitioner to file an additional affidavit within the next 2 days and giving opportunity to the learned senior government advocate to file the response to the petition and the additional affidavits within a period of 2 weeks. From today, list this matter again on. Tell us a date.
3/6. 27 তারিখে 28 তারিখে দিব পারি। 3 তারিখে।
3rd of June?
3rd of June.
3rd of June.
List the matter again on the 3rd of June. The learned senior government advocate shall ensure availability of the records in the matter.
Yes, ma'am. Okay.
You need not retain them, but you have it
Yes,
on the
ma'am.
next.
Obliged, Your Lordships.
Much obliged. From the supplementary cost list for orders, item number 41.
Item? Yes, steps not taken.
Lordship, we have already served a copy to the standing council, Lordship.
But the appellate authority, he cannot take.
Yes, Your Lordship.
Huh?
To ED, Your Lordship.
ED 1 and 2, fine. Notices have been issued to all the three. The pro forma respondent also. But the pro forma respondent,
Necessary.
would not be necessary. Now, where is he? They'll have to at least come and tell us that we have accepted, so that is final.
Yes, Your Lordship. In fact, this morning we talked to him. I talked to him. It seems he is in Bangalore, Your Lordship, attending a sick brother, Your Lordship. Hospitalized, it seems.
A prayer is made on behalf of the Learned Council, Learned Standing Council, Enforcement Directorate for an adjournment in the matter. It is submitted that the Standing Council Enforcement Directorate is not present in town and is presently undergoing medical treatment.
His brother is.
His brother presently in town, presently out of town in connection with the treatment of his younger brother,
Yes, Lord.
So accordingly, when is he coming back?
I don't know, Your Lordship.
Accordingly, register to list this matter again on 28/5/2028. On 10/6/2026.
For orders, item number 42.
Prayer is made on behalf. Prayer is made that the Standing Council, Enforcement Directorate, representing respondents number 1 and 2. What is this item?
Me, please, my lordships. Lordship, I am humbly seeking the discretion of this honorable court for condonation of delay of 579 days in filing the main appeal. Lordship, my humble prayer before this honorable court that I am the landowner of the existing veterinary office at Authorised. Now, the state government has adopted a scheme for landowner appointment in grade 4 posts.
Madam, there is a private respondent. Respondent number 5.
Yes.
So we'll have to hear them once. How can we ex parte pass that order of delay condonation? Laha. Heard Miss so-and-so, Namgita Luilabade. Learned Counsel for the petitioner, also heard Miss so-and-so, Learned Government Advocate, appearing for the Government Advocate. Also, the present interlocutory application has been instituted, praying for condonation of the delay or delay of 579 days in filing the connected appeal, assailing the judgment and order dated 28/8/2024, passed by the learned single judge in WPC number 38/2022. Full stop. Para. Issue notice returnable 4 weeks. Para. Miss.
Lordship, honest, what if I'm not bringing before this honorable court for disturbing her regularization?
Be that as it may. Miss so-and-so Government Advocate accepts notice on behalf of respondent number 1, 2, 3, and 4. No formal notice is required to be issued. However, requisite extra copies. No formal notice is required to be issued. Paila. However, requisite extra copies of the interlocutory application be furnished, by the petitioner, Learned Counsel for the petitioner to the Learned Government Advocate. Full stop. Para. Petitioner to take steps for service of notice upon respondent number 5 by way of speed post. Full stop. Steps within 3 working days from today. Registry to list this matter again after 4 weeks on a date to be fixed by it.
Obliged, Lordship.
For unlisted motion, item number 43. WP Criminal 11/26. Lordships. My lords, the petitioner hearing is seeking for revocation of the detention order dated 8 April 2026. Amongst other grounds, my primary ground is that while serving me the detention order, which is at page number 25, my lord, at page number 26,
You've given me some emails.
And that is item number 2.
so at page number 26, the detaining authority have informed me that I had a right to make a representation to the detaining authority, central government and state government, to the concerned jail authorities.
Same.
Page number 26. I've been informed of my right, that I have a right to make the representation to the detaining authority, the state and the central government, to the jail authorities. Thereafter, on 14 April 2026, my representation is at page number 30. I filed my representation, and the same was forwarded by the jail authorities to the detaining authority, my lord. Same was forwarded. But till then, my lord, the detaining authority has not disposed of my representation. Almost 1 month. The central and state government has rejected my representation, but the detaining authority has not disposed of my representation.
No, it was sent to the board, advisory board.
No, to the detaining authority, the commissioner of police. And
No, he has passed the order. It was forwarded to the
my lord.
government.
My lord, the detaining authority has informed me that I had the right to file a representation before the detaining authority at page number 26, my lord. At page number 26. No, my lord.
Now tell me.
Are informed.
Okay, fine. Tell me that this is the only point.
I have other additional points that.
Okay. Now show me from the act that once the detaining authority has passed an order.
Yes, my lord.
And it is confirmed by the state government,
my lord.
he still retains a power to
my lord.
Review this.
My lord, it has not been confirmed yet. My detention.
This.
Given, my lord.
And what happened? What happened before the
detaining authority has the authority? The detaining authority has the authority to revoke my detention, my lord.
Okay, we'll consider.
Yes, ma'am.
You have your instructions. Get the records. Mr.
SOP, my lord.
S. Sophie, learned S. Sophie, A. Sophie.
SOP, ma'am.
Sophie, SOPHIE, learned counsel for the petitioner. Also heard Mr.
M. Longcomar.
M. Longcomar, government advocate, appearing for the state respondents. Issue notice returnable when?
28, Your Lordship.
28/5/2026. So, Mr. Longcomar accepts notice on behalf of all the respondents, right? No.
Yeah.
On behalf of respondent number 1, 3, 4, 5, and 6, right?
Yes, Your Lordship.
While CGC, who is the CGC?
I have already served a copy to him, my lord.
Who?
Zeren Muli.
Full stop. No formal notice is required to be issued. However, requisite extra copies of the issue, same goes to the petitioner to take steps for service of notice upon respondent number 2 through the learned CGC Kohima bench. Right?
My lord.
Steps within 2 working days from today. Full stop. On the returnable date, the learned government advocate shall, in addition to bringing on record its response to the grounds taken in the present petition, by way of filing an affidavit, shall also furnish the records in original.
Got it.
So, registry to list this matter on 28/5/2026.
Obliged, my lord. For orders, item number 44. IA Criminal 22 of 26.
May I please, your lordships? My lord, while filing the criminal appeal, I have filed one IA
Yes. My lord, that very doctor, surgical doctor has clearly written
Yes,
place
sir.
for surgery. However, the medicine doctors,
Any surgeon before taking up a medical procedure has to refer him to the medicine doctor
My lord,
to
yes.
find out whether what are the medicines that are being taken, what is the present situation of the person. This document does not show that you are not fit to undergo the operation. Where does it show?
of course, my lord, it is not written.
Then
However, he was advised to come only after a month after this medication, my lord.
Okay.
written part has to be there.
And that
1 month to nahi 1 month to
Again, continue medical set at 2 months level. Completed 2 months.
till date.
Till date, he has completed 2 months of medicine. That is reflected. Then
Nothing.
the next page, there is no date.
Silata T, metformin is for his diabetics, is 6.1.
No, this is not ready for. Get us a document
My lord,
from your.
my lord, then allow
Lighting doctor.
if this matter can be taken up to tomorrow, so that I may
Sorry.
bring necessary recommendations.
No.
If the doctor is able to recommend, because from here I cannot show that because
That's something which you should have arranged for when you filed this application.
no, my lord, but when the verbal advice was given in
Yes, what do you say?
As far as or just they will allow to withdraw and then to file a fresh first.
You surrender with your medicines. We will provide that. We'll provide you liberty to approach this court as and when the operation date is nearing. You can come renew your right. That much of it. We have it in the first half because your date of surrender is on 14. We want you to, if we reject it, we want you to surrender tomorrow. If we can have it in the first half, nothing like it.
my lord,
The prayer of the learned counsel for the applicant petitioner, register to list this matter again tomorrow.
bless you.
We'll take it up as the last item, but you get us something.
My
Otherwise, we'll not.
my lord, bless you.
For hearing item numbers 36 and 37.
May I please your lordships?
Yes.
Lordships. Here, the challenge has been made against the finding of the learned single judge on 4 grounds. That is, the learned single judge has failed to appreciate the fact that the petitioners in the earlier writ petitions have participated in the recruitment process. That is, advertisement was issued on 7th of April 2025. Recruitment process started. That is, physical days started.
Who are you?
I am the recruiting authority.
Recruiting authority.
The state.
Okay, we'll cut the matter short, no problem. There was an advertisement issued. And the rule says that it should be by way of a competitive examination.
Correct.
Right? But in the advertisement, it was only PST or physical endurance test and the Viva.
Correct.
So once the body was constituted, thereafter the authorities of the body issued a corrigendum saying that we will have a written examination. So that was put to challenge.
Yes.
But the learned single judge found that this was changing the rules of the game after the game had begun, and accordingly interfered with that, giving you liberty to do it afresh.
Correct.
Right, that much only. And this court has not stopped you, but has said you proceed with the selection. And no, division bench order.
Yes, Lordship.
That you proceed with the selection, and it will be subject to outcome of the present. So what happened to the selection process?
It has been completed.
Completed.
Yes. In the month
Appointed?
of February.
Appointed people?
Not appointed. Without the leave of this court, we haven't taken any decision.
You have the rules with you?
Lordship, I have the rules with you.
Wait, page 30. A recruitment to the service applicant shall be made by direct recruitment to competition. The advertisement?
Lordship, page 18 of the memo. Page 18.
1-8.
Yes, sir. Lordship. It is shown for 40 posts of excise constables. However, by an addendum, it was increased to 46.
Date of physical test, suitability test, viva voce. And where is the corrigendum?
It is an annexure F. Lordship, it's page 29, annexure I.
So this was issued before the recruitment process had started.
Not yet started. Yes.
Before it started?
Yes, Lordship. Because recruitment only started
In the month of July.
Which memorandum?
That is page 19, Lordship, in Exhibit B. This was issued by the Commissioner of Excise and has no government approval.
No, whether it was a government approval or not, you had taken the 80 meters race, you had taken the long jump, you had taken the high jump.
Yes.
Why are they saying it's watered down?
Otherwise,
Paragraph 20, they have. In paragraph 20, I have clearly stated the tests that were applied. And whereas in the memorandum, if your lordship may go to the memorandum, it is clearly laid down. Page 19 and 20. These are the tests. Page 20, your lordship. In the memorandum of appeal. 100 meters, 800 meters, long jump, high jump, short put. All these are there in the memorandum. Whereas during the test, in my paragraph 20, that is, if your lordship may go to page 57. Page 57.
Now, have you participated in the?
Your lordship, I submitted a representation prior to the test.
Have you after this court had given them the liberty to go ahead with this?
Your lordship, yes.
After this court had given them the liberty to go ahead, did you participate?
No,
in the
no,
test?
no. We were not called, your lordship.
You were not called.
Because the written exam was conducted, we did not appear, your lordship. Because in the meantime, we filed immediately on the first day when the test was conducted. Since they did not go by the memorandum,
you did not appear in the interview.
On the physical test only we applied. Then immediately thereafter we filed this petition.
And you did not appear in the.
It did not, your lordship.
In the written.
No, Lord says that they appeared in the written exams as well. There's nothing like.
Mr. Counsel, Mr. Counsel, have you appeared in the physical age test?
Yes, but then after objection.
No.
Because once I have given objection saying that if it is not conducted as per the first advertisement.
No, where is the material to show?
Your lordship, I'll take your lordship to the application, the representation which I submitted.
No.
Page 106.
After you appeared in a selection process, after the orders, after you filed this writ petition, the physical was after the petition or before the petition? Before.
Yes, we've submitted a representation saying that it should be conducted as per the first advertisement.
What is the digression made from the office memorandum?
Yes.
That where do I get
Yes.
it? What is the digression made?
Your lordship, at page 57 is my petition, at paragraph 20. Page 57, paragraph 20.
Sixteen second on 100 meters from Gauhati.
It is the fitness. That is the fitness.
It is not denied by the department. They went by this. Because of that, immediately after the physical test.
Yes, who decided on this?
Lordship.
This criteria at page 57, para 20, who decided?
What will be the tests which will be taken of the candidates?
Who decided? When? Where?
Page 57 of your appeal. Page 57, paragraph 20.
Writ petition report.
Is a part of the writ petition. Now there were 3 tests taken. Yes?
This was the decision of the TRP, Departmental Recruitment Board. Decision of the TRP.
But you have to put down all the tests before you start it.
Yes.
Lordship, you have to say this is the mode of selection,
Yes.
even before the selection process starts. DRB will come at a later stage. People have to know what they are participating in, what will be the test that they'll be subjected to. Even a
Physical test, physical test. They don't have it in memorandum.
These will be the relevant tests. And that written test part, who decided that there will be a written test?
The TRP itself. The TRP.
Who is the recruiting authority?
The recruiting authority is the.
Now, who is the employer?
Employers, the Department of Excise.
Right. Now, the Department of Excise issued the advertisement, not the DRB. Who issued the advertisement?
Issued by the Department of Excise, not the TRP. TRP is only considered for recruitment.
So that Department of Excise has to tell the selection board, select persons according to this.
No, Lordship. To give an answer to that, advertisement was issued. Criteria was also included in the advertisements. But otherwise, the race notifications with regard to running race or the high jump, long jump were already placed in the notice board. So the candidates, aspiring candidates, are well aware that
in today's date, with today's technology, you are saying that you are putting that in the wooden notice boards for people to come and read it in your office.
No, Lordship.
Advertisement was in the wooden box, in the notice board. No.
No, but Lordship, in this case, the petitioner have willfully participated. Waive off their right. They cannot turn around and question the validity of.
No, there is an objection submitted. There is an objection.
They have given a representation without prejudice to their rights. They have participated because they do not know what is happening. They expect you will follow the rules. You will have all those memorandum tests. They appear. They see that there is no test. They do not know whether they have passed or failed. They immediately give you a representation even before the results are up. They are before this court in a writ petition, saying that, sir, there is something wrong going on. Even if we pass, it will be wrong. This is not the way a selection is conducted. So there will
first there was a physical endurance test.
Yes.
Then written examination.
Yes, subsequently. So immediately on the first day,
endurance to pass.
No, of us appeared. A few of us appeared. And then we came to know that
challenge is not to the burden of the endurance.
No, it's to the process.
You are violating everything.
They have been making the rules along the way.
No, but Lordship is the advertisement condition number 15. We have already expressed that any omission or commission will be rectified through notification and attendance.
Where is the notification, sir?
Where is my lord is asking, where is the notification notifying the time within which you have to complete a race? The long jump you have to complete, high jump you have to complete. If you say you're not following the office memorandum, what are you following?
When did you tell the candidates this is what we will follow?
Because in all the advertisements for such recruitment, there is a specification given that this would be the physical endurance test, this would be the time you require. We are not with him with regard to that written examination. But this point we cannot ignore. And the learned single judge has also said that follow that office memorandum. Other part of the judgment, maybe we will rethink. But this point, you will have to satisfy us.
One pertinent issue is whether they can turn around and caution.
Those things have gone because they don't know what is there. So they ran into that storm. Once they reach that storm, only when you go in a plane, you sit in a seat, you don't get a turbulence. You get a turbulence only once the situation is developed. So how can he say?
As of now, Lordship, I have no answer to the.
You get your answer.
I will get it tomorrow. If I will listed tomorrow.
Also, you tell us that DRB, who were the members in the DRB?
It was a notified question.
Okay.
DR,
That is at page 25.
Your Lordship.
And you are saying that this has been done? This page 29 is by the DRB?
The DRB decided.
Yes, Lordship, this is decision of the DRB.
Yes.
Can the DRB decide to override what is there in the advertisement? The DRB is a lower body than the appointing authority. Appointing authority is at the
Correct,
top.
Lordship.
They have asked the DRB, please do the selection.
Yes.
We will have these tests. Now DRB says, no, I will add one more test. Can he do it without the appointing authority approving it?
Lordship, that part already the rules prescribes that selection should be done.
That is exactly what we are telling you. When the appointing authority, when the person who is recruiting says that I want to have a viva and I want to have a physical test.
On that point.
You show us that the body given the authority to select can also introduce the nature of examinations.
Lordship, once,
Suppose it is said that you would hold a viva
Lordship,
and the selection body, the selecting committee, they sit down and say that we have 5 persons. You ask about the health. I will ask about the nature. You ask about some psychology questions. That they can do. We will also introduce a physical examination into the entire scope. Can they do?
Violation of
They will keep on introducing new and new examinations. Appointing authority will never know what is happening down below.
no, Lordship, these things are done within the preview and ambit of the rules, not beyond the scope.
What is this DRB? How does it come into existence?
Departmental Recruitment Board.
Yes.
It's a board of the department.
No, it's a board under the rule. Therefore, under Rule 7 of the Excise Service Rule. As per the rules, so they will have the power
To do what?
to see that the recruitment process is done as per the rules, because they are created from.
This is for the
Rule
post of constable.
7. Constable Lordship. But Rule 7 also says that for promotion as well as for recruitment of inspectors, excise, head constables as well.
Only that much. That recruitment will be in terms of some set norms. Now, who will set that norms? Whether it will be set by the board
Your Lordship,
or by the authority.
Your Lordship may go to the section 5. Two. Section
Section 3.
2. It is for the government to consult a commission, adopt such methods of recruitment to the service.
Now, the commission would come in only in cases of inspector of excise and above.
But whatever your Lordship asks for, this is a general rule, yes. So it has to be the government which must decide, not the board.
And
Even the constitution of the board.
this decisions of the board, was it ratified by the competent authority in the department?
No.
Lordship, the committee itself is comprising of the Commissioner of Excise. He is
nothing. He is nothing. It's a directorate. Who is the authority in the department? You have a separate commissionerate for excise here?
Yes, Lord.
So that is a directorate.
Yes.
It's not the government. The government is
the secretary.
A secretary.
Yes.
So whether the approval of the governor, because you have a 309 rule now. Now, when you have a 309 rule, you must have the approval of the governor if you have to tweak with this. Get your thing. But the Learner Council for the parties. Also, the Learner Council for the appellant submits that he be granted time till 10/6/2026 to place on record the manner in which to place on record instructions as to the power of the departmental selection committee. Department Selection Board.
Recruitment board.
Departmental Recruitment Board to prescribe the manner of recruitment and also with regard to the qualifying standards thereof. It has been of qualifying standards thereof. It is the case of the respondent that the DRB without any authority had proceeded to prescribe a written examination as well as to prescribe qualifying standards in the physical efficiency test in violation of the standards prescribed in this connection by the department earlier.
Yes.
So, registry to list this matter again on 10/6/2026.
Also look into another aspect of the matter. This is a rule under 309.
Yes, Lord.
In these 309 rules, if you want to make any changes or if you want to introduce or take away anything, the governor has to be
Correct.
okay.
Correct.
Now here in your schedule, at page 10, the excise constable post is there.
Lordship.
Yes. Then in page 11, the pay scale, the number of posts to be filled in is there.
Correct.
Then you will also have it in page 13, the excise constable, and page 12 is excise constable class 8 pass. Then you have schedule 5, the syllabus. This syllabus does not contain anything for constables, sir. So how could you introduce a syllabus for the constables beyond the rules? No one questioned it till now, you were safe. He questions it, we have to answer it.
I'll answer to those.
Or your whole selection goes.
Lordship.
Or it has to be redone from the stage of physical. All those who had applied from the stage of
Otherwise,
physical again.
It has to start off with.
And they will run again.
For hearing, item number 38.
Yes, sir. What is the error?
Lordship, the impugned judgment and order was passed on this.
Now we got it. What is the error?
Lordship, there was an observation in the impugned judgment and order. One aspect is that on the factual aspect, Lordship, that the respondent departments,
they may not be able to trace the record of 2010 and 11.
We'll not go into that.
And
If you had approached the civil court in this matter,
Lordship,
the limitation would have been 3 years.
Lordship,
It's open to you to file a condonation and get it.
Lordship,
But the limitation is 3 years.
Lordship.
Now, strictly not there, but it still would be, the principle would apply in a writ petition also.
Lordship.
In your writ petition, you had not explained the reason for the delay.
Lordship.
Secondly, there is no acknowledgement of this debt by the department after the, say, 3 years have passed away. So if they acknowledge that, you get a extension of the period of limitation.
Lordship.
It's not there.
The reason why
The learned single judge has already given you liberty. Approach the civil court.
Lordship, since my humble understanding was, Lordship, since the amount is already been admitted, it's not a disputed amount.
Who admitted?
Lordship, the respondents, Lordship. There's a communication, Lordship, in the app.
Where?
Lordship, may kindly come to page 43 of the appeal memo, Lordship, 43. And Lordship will find the type copy at page number 44, Lordship.
Dated? 42 is dated?
40, 10 August 2011, Lordship.
2011, under
Yes,
3
Lord.
years.
2011,
2014.
Lordship.
And after this, is there any acknowledgement by the authorities?
Lordship, I could not obtain such reports, Lordship, while approaching this on the court.
One of the reasons why the limitation is given,
Lordship.
this limitation, the records will not be there. People will not retain all the records for 20, 30, 40 years.
Lordship,
Why should they?
my explanation is only paragraph 22 of the writ petition, Lordship. Page 33, Lord.
This is no explanation.
Salaries are refused beyond 3 years.
Areas you don't get.
A year salary you don't get beyond 3 years.
Lordship, my respectful submission before the honorable court is since the amount is admitted and there's a continuing wrong, Lordship. So even the injury also continues.
No. In this, the continuing wrong will give you a limitation for 3 years. You will have to institute a proceeding within that 3 years. If not, explain the delay. Neither is here. So why should we come in and if we pass an order directing them to consider and pass, then if they don't have the records, they still will be in problem because they need not keep those records for 40 years. You have not come after 2011, fine, gone.
Lordship, just one aspect, Lordship. This writ petition was dismissed on the first day of motion. And there was no opportunity for the state respondents to bring on record.
No.
Whether there's any such records is available in the...
That would be, the pendency of the writ petition would have been an empty formality. After 5 years also, it would have been the same.
Lordship, is if sometime may be given so that I may do some more research.
No research.
If
you
some
go
more
before the civil court, you explain the delay.
Lordship, on the next returnable date, if I may be on the next occasion, Lordship, if just a 2 weeks time, Lordship, 2 weeks time.
I'm sorry. Nothing is there.
Because Lordship, my kindly appreciate another aspect, Lordship. I have invested all my resources.
If you have,
I have invested all my resources. I have not received even a single
explanation, Mr. Counsel.
Required resources for the last how many years?
Lordship, I have been approaching the department, Lordship. My way of representation as well as a legal notice was also filed, Lordship. There are 3 reports, Lordship. 2 representations and a legal notice, Lordship.
2011, then you were sitting tight till 2012. Thereafter nothing. Thereafter nothing. Then 2016. Then 5 years you were waiting. 2022 you put in a legal notice. And then,
Lordship, if I may be allowed, it's 2 weeks time.
then maybe this court had, then you file a writ petition, you withdraw that. Then again, with the change, you again file another writ petition. 12/2/26, and what is this? Next month itself you come back. Your writ petition literally was dismissed on 17/2. The formalities was done on in the month of March.
Lordship, if I may be allowed another opportunity, Lordship. Just 2 weeks time, Lordship. Because if I fail here, Lordship, I won't have any other alternatives.
Okay, you are so persuasive, we can't say no. On the prayer of the Learned Council for the appellate, registrate to list this matter again. Can you have it next week or the week thereafter? Next week I'm here.
After 2 weeks.
Then better. 27th, so till 3rd, you can't have it because the author of the judgment will be here. So it will be on 10th.
Lordship.
On 10/6/2026. Try.
Authorized.
You know the mind of the court now, so you explore. There are some judgments already appointed. What only the difference between the answer the department. The respondents on the next, by the next date of listing shall bring on record their stand by way of filing an affidavit. Now we are giving you an opening. Try.